In the next week, Lordship. I've taken the consent of Mr. Saraf.
No, not next week, right? Uh, on the prayer for adjournment made by Mr. RKD Chaudhary, Leonard, Deputy SGI, which is not objected to by the Petitions Council. This is the matter after 2 weeks.
No, but
Yes,
Item number 5 of the daily list. The person of the other. The target council is not today.
Huh?
The target council is not present today due to some.
who is the arguing council?
The matter.
Adjournment prayer has been made on behalf of Dr. A. Sharaf, Learned Counsel for the petitioner. The matter pertains to the rejection of the claim for Central Capital Investment Subsidy under CCISS 2007 and NEIIPP of 2007 on 7/1/2019. The prayer for adjournment is allowed. This is the matter after a week. Next,
May I please, Lordship? I pray for listing.
after a week.
I pray for listing
Huh?
of a repetition, Lordship. Admission. It was last listed on 31st May,
Give a date.
9.
Highly
Highly obliged.
to mention, my lord, for listing for admission, my lord, or fourth, my lord. Next week, Wednesday, my lord.
Okay.
Lordship,
Lordship, I beg to mention item number 45. In this case, Lordship, we filed a small two-page affidavit, additional affidavit to rectify an inadvertent error, Lordship. So the recordment is followed.
Affidavit for error?
Lordship, actually, the.
You mean the application?
In the writ petition. No. In the main writ petition, it was filed, it has been allowed, the mention was allowed yesterday, Your Lordship.
So?
We have filed an additional affidavit to rectify an error, Your Lordship. Annexure was.
How can you rectify an error by way of an affidavit unless it is an application?
Yes, Your Lordship, we have filed an additional affidavit just to mention that the annexure
Error.
was wrongly placed, so the numbers need to be corrected.
And I call, didn't see. what-
Lordship, in item 22, Lordship, as has been instructed by the petitioner, matter became infectious.
Okay. Mr.
J.M. Gogol.
J.M. Gogoi, Learned Counsel for the petitioner, submits that the matter has become infructuous.
Okay.
Who appears for the other side?
Lordship,
Mr. R.R. Gogoi appears for the Forest Department. The writ petition is accordingly dismissed as infructuous.
Okay.
With regard to item number 13, you know, with regard to not very.
Huh?
With regard to. item
13,
number
yes.
That will be taken after 2 weeks.
No, I'm taking it up today.
Did you not?
Huh?
Wednesday next.
No. What?
We have put a respondent on.
Therefore, the respondent, so.
It is not fair.
No, we'll let us hear the petitioner. Let us hear the petitioner.
Did not.
No adverse order will be passed against the respondent.
Your Lordship, I'd like to mention item number 18.
Huh?
Item 18,
18, yes.
we are for the respondent. We
Yes.
need to file the affidavit in opposition. So my lord, you may grant 4 weeks time to file the affidavit in opposition.
Okay,
And there
Mr.
is an interim order
What?
in favor of the petitioner.
You're not filing, you're not interested. You're appearing for whom?
I'm for the private respondent.
What's your name?
Pannalal Sutradhar.
Your name is not here also.
Respondent number 4.
Your name is not here. Have you filed Wakalatnama?
No, I'm appearing on behalf of M.K. Chaudhary. Manzoor
M.K. Chaudhary. Okay, Mr.
TL Chaudhary.
T-
TL Chaudhary.
T. A. Chaudhary appearing on behalf of Mr. M. K. Chaudhary, learned counsel for the respondent number 4, is granted 2 weeks time to file affidavit. This is the matter after 2 weeks.
Okay.
After item number 32, Lordship, I'm appearing for Junchi authority. In this matter, Lordship, my instruction is awaited. So may I adjourn this meeting, Lord?
What was the last instruction?
Instruction filing affidavit, Lordship. In fact,
No, you have not returned the earnest money deposit.
yes, Lord.
Then
Return of earnest money, Lord.
why you
That
not?
instruction only awaited, Lord.
So what is there? What is there? What is there? Only earnest money deposit. Why has it not been returned? You give me that. Give me that file. Sorry.
Okay.
It's a simple issue.
Good.
You have. Yes. Work has been allotted to somebody else.
Yes, Lord.
They're supposed to get the MD.
Yes,
What is
Lord.
that?
I already made my communications, Lordship, on 310.
Then you tell them to appear. What is this? You're cheating you're cheating this petitioner.
Lordship, grant me one more opportunity, Lordship.
Huh?
This is new method, one more opportunity, Lordship. Today is the second day only.
Right. Mr. P. Nayak, please for time to obtain instructions as to why the petitioner's earnest money deposit has not been returned to him, despite the contract having been awarded to the
Respond number to Lord.
respondent to whom?
That party is not my party.
To one of the bidders. One last chance is provided to Mr. P. Nayak to provide instructions, or else the concerned officers would have to appear before this court. This is the matter on given it. Short it.
Which is like 14 of the.
Huh? Item 2018 matter. Are you sure when did you last speak to your client? What did he say? So you want to file reply. Mr. MP Sharma, learned counsel for the petitioner, is granted 2 weeks time to file affidavit in reply. First of the matter pertains to grant of subsidy on education loan. This is the matter after 2 weeks.
Yet we should Lordship, item number 4. WBC number 6275.
Huh?
WBC number 6275.
Yes.
Lordship, under the instruction of our client, of our petitioner, the method may be allowed to withdraw.
Okay. Mr.
Mr. H. Bora, I am appearing on behalf of Mr. A.K. Das.
Mr. H. Bora appearing on behalf of Mr. A.K. Das, learned counsel for the petitioner, submit that he has been given instructions to withdraw the writ petition. The writ petition is accordingly dismissed as withdrawn.
Item 44 for withdrawal.
Huh?
Regarding settlement of a written application.
Mr. P. Bhardwaj, learned counsel for the petitioner, feels that he may be allowed to withdraw the writ petition with liberty to file a claim. Mr. S.S. Roy,
One
CGC,
and two. No, Lordship, 1 and 2.
appears for the file number 1 and 2. The pair of the petitioner's counsel is allowed. Writ petition is dismissed as withdrawn, with liberty as free. Okay.
Item one for motion.
Heard Ms. N. Saikya, learned counsel for the petitioner who submits that the petitioner's representation has not, representation dated 8/11/23 has not been decided. Despite the order dated 18/10/23 passed in WPC 6216 of 2023. Issue notice returnable in 4 weeks. Petitioner takes steps for service of notice upon the respondent by registered post with AD within 3 days. This is the matter after 4 weeks.
Item two.
Heard Mr. D. Chakrabarti, learned counsel for the petitioner. Yes, can it be disposed of or what?
Notice my date.
The learned counsel for the petitioner who submits that the contractual dues of rupees 1,44,11,300 has not been paid. Issue notice returnable in 4 weeks. Ms. D. Jain accepts notice on behalf of
Respondent number 1, 3, 4, 5, 6, and 7.
1,
3,
3 to
4,
7. Who's for 2?
Worship to is Finance Department.
Mr. Bor Pujari is there or no? Oh. Huh?
Respondent number
Yeah, finance. Mr. R. Bor Pujari accepts notice on behalf of respondent number 2. Extra copies of the writ petition be provided to Mr. R. To the respondent's counsel during the course of the day. This is the matter after 4 weeks.
Notice on respondent number 8.
Okay. Petitioner takes steps for service of notice upon the respondent number 8. By Baputa board.
But we have registered.
Acha. Point number 8 by registered post with AD within 3 days. This is the matter after 4 weeks.
of the
Item three.
So, madam, again, this is D voter.
Yes, your lordship.
So, Mr. A. Rashid, learned counsel for the petitioner, also heard Mr.
Say paying for my lord respondent,
J. Payang for
respondent number 2 and 4, my lord.
2 and 4.
Yes,
2 and 4.
P. Barua, your lordship.
P. Barwa for
For 5, your lordship.
Mrs.
Yes, your lordship.
Mrs. P. Barwa for respondent number 5. And S.R. Barwa for
Number three.
so this you're in the voters list of 2017. You're with me D voter, correct?
In English, my family has been good, but there is no any case I have been.
Anyway, in the 2000s, huh? You want to? You
Been good in the apprentice time, respective.
97.
Those studies were from 1997.
97.
97.
not 17.
No.
1997.
Yes, sir.
Yeah, 2017 also we learned that.
So after from 97 onward, it carried on.
Yes, yes.
So initially 97.
Yes.
Correct. And so mark D in the voters list respect of serial number 861. 861 Golpara West. LAC number 38. Correct. Okay. So we'll similar order.
Yes.
Just to mention, your lordship, can you mark my appeals for 7 also, which is the district election officer?
Acha,
Five is
for,
11.
so you're for
For
5 and 7.
7, your
5
lordship.
and 7. Okay.
Much obliged.
Disposal.
Item six.
So you were building a house for your own house. And you took permission. You asked for permission. Permission granted or not granted? Not granted. Unless you pay the 2% royalty. But that's not what you mentioned in your writ petition. The problem is you said that permission granted. You write something else and you say something else. permission is to be granted by whom? You have got no idea.
Building permission by GMDA, NOC by GMC.
But so GMDA did they give permission? No.
Here, one line he stated, Lordship, after approval and sanction of the.
That is what, that is actually, unless, according to it should be, unless the money is paid, then only you are going to give approval.
Not.
Actually, you're writing wrong facts here, that's the problem.
Similar.
Look, the law is clear. Your facts are not clear. It's like saying, unless I wear white clothes, I will not be given permission. And you are saying, permission already granted, though I am wearing black clothes. So it has no meaning. Your writ petition has no meaning. Anyway, I think it's a covered matter.
Otherwise, issue is decided.
Give me the judgment.
Yes, Lordship.
Well, at least write the correct facts. Don't say that your thing has been approved. It has not been approved.
Application.
Approval will be given only if the 2% forest royalty is given. That should be your case. That is, but your case, and that, so basically your prayer should be that 2% royalty should not be, not required to be given, and permission has to be given. But your case is that permission has been given.
No permission has been. Lordship, may kindly say page 29.
29. No. It is government.
Statement is there, Lord.
Government statement is there.
For other than forest royalty, Lordship, about planning permit and building permit also he requires pay something, Lordship. That has also not been paid, Lord. Lordship, may kindly say page 29, first one, planning permit unpaid. Building permit unpaid. So,
Page 29,
yes, Lord. Annexure C.
NHS is 27.
My presentation is not correct.
27.
Page 27.
Unpaid.
There is no question
Huh?
of issuing it. No, this is the, not today, Lordship, it is required to submit online, Lordship. The payments are also required to be made online. So unless you pay, there is no question of giving you the building permission, Lord.
So he will
So-
pay and then you will return it or what?
There is no question of returning, Lordship. Building permission has not yet, the payment required not yet paid, Lord.
No, but that 2% royalty is not required to be paid.
2% will come later, Lordship. That has not yet been rejected. Although the issue has been decided, Lordship, in his individual case, Lordship, no sanction has yet been issued. That is my.
But out here he has said that
Yes, sir.
permission granted. That is what, no, please write the correct things. No permission has been granted to you. And you are saying it has been granted. Your documents say that it has not been granted. Yes, what? Are you going to correct the mistake in your averments?
My submission is his permission is not pending because of the forest royalty.
Huh?
His permission is not pending because of non-payment of.
Correct,
forest royalty. Other
but
issues are also there.
and his averment is that permission has been granted. But documents say otherwise. And where is the letter asking you for the 2% forest royalty?
Not an Excel. Not that.
Page number 38. Okay.
That's a notification.
Huh?
That's a notification. For that.
38 is a order, giving interim order. This, now forget the order. The issue has been settled in your favor. Only problem is there is nothing to show that they are demanding 2% forest royalty from you. Where is that document? Or where is that averment made by you in your writ petition? Do you understand what I'm saying? Or you've got no idea? Do you understand what this court is saying, is this your writ petition? Your writ petition. Why is the building permission not given?
That instruction I have to take, that lordship, as it appears, lordship.
Let us see his prayer. His prayer is to exempt the petitioner from paying 2% royalty. That too he'll be exempt.
No, he is saying why the impugned communication annexure shall not be set aside.
Annexure E.
Annexure is the OM lordship. Notification.
Okay, we'll clarify that. That annexure E has already been set aside in a different case. Correct. Where is that annexure E?
Page 32, I think.
35.
32. 30. 30. 30.
Mhm. This notification has not been set aside. I think the communication made in person to this notification has been set aside. You're challenging the wrong document. You're just doing copy paste. No, no idea what you're writing also. It appears. You're confused. I am even more confused now. You see, you have got to challenge this page 34. And this page 34 doesn't even require to be challenged because it has already been set aside in another judgment. I'm not issuing notice, by the way. You please clarify. What do you want to do with this case?
I'd like to withdraw to liberty to finalization.
And please understand your case, okay? Please understand your case. First of all, you see, you just take it down. Judgment and order dated 24/9/24. Write it down, pen, paper. Judgment and order dated 24/9/24. Passed in WPC 4085 of 2024. Okay. Now by this order, the communication dated 2/3/2023, 2/3/2023. That is here, your annexure F, page 34. This has been set aside. Your page 34 has been set aside. So that takes care of your entire case. Okay, just keep it. Okay, right. Heard, Mr. F.A. Ahmed, learned counsel for the petitioner, who prays that he may be allowed to withdraw the writ petition with liberty to file a claim. Mr. P. Nayak appears for.
I'm appearing for lordship 4, 4, 7, and 8.
4, 7, and 8. Mr. R. Govey appears for
Response number 1 and
1 and 2. Mr. S.R. Baru appears for
3, 5, and 6.
3, 5, and 6. The prayer of the petitioner's counsel is allowed. Writ petition dismissed has withdrawn. Come up with liberty as faithful. Same order. So only thing you've got to pray for in your writ petition is that they should, the GMD and the GMC should give you permission to your building plans. That's all. And you can write in your writ petition that order on the which has been made on the basis of that gazette notification that has been set aside. So you don't have to pay 2% forest royalty. So that judgment you can annex it in your writ petition. Yes,
Yeah, absolutely limited period. I have a hotel at Durbar. From 2015, I have been availing the electricity benefit connection. And from 2015 till date, my lord, I found that the charges are too high. So therefore,
what is too high? The bills are too high.
I pay. It's not that I am not paying. Whatever bill has been there.
So what do you want?
I have, my lord, installed sub-meters. Now, the sub-meters and the main meter, there is vast variation.
Sub-meters installed by you,
By that.
by them.
Because sub-meter I cannot purchase from the market and install it. So therefore, I make several representations. One representation I have connected the petition. I just want the verification of the entire matter, my lord, and let them resolve it. That's it.
There is otherwise a statutory alternative remedy before the CGRF, your lord. If he believes that he has been overbilled or the meter is incorrect, then you can avail the statutory.
Can you verify his sub-meters?
Because once we have billed, your lord,
Because one thing is that, you see, once we allow everyone will do it, then what
Yes.
happens? Huh? And the whole of Assam will come here.
there is a remedy specifically set up for these purposes, your lord. People who have complaints.
Petition relegated because
Huh?
the petitioner be relegated, my lord, to that authority. Because it will be an issue of my lord, determination of fact.
Yes.
I can understand. It's,
Tomorrow everybody will come here.
I have laid so many representations that it is not a case that I am not paying.
But you did not go to the authority, the concerned authority.
I had made representations and one or two.
Where is to the concerned authority, where?
I have stated whether that one or two they came, but they didn't do the needful.
Okay, where is the authority?
Lordship, it will be for the CGRF. The authority, your lordship will find that page number 9981.
Huh? 9981.
9981. The Consumer Grievance Redressal Forum.
The Consumer Grievance Redressal Forum.
Yes, and there is an appeal against any order passed by this authority before the Electricity Ombudsman.
So, what is the
The nature of disputes, your lordship will find at 9978, your lord. Rule subclause 3, your lordship, 9978. 3.1 DNE would be relevant, your lord.
DNE?
Yes.
So they've got to go to this CGRF.
CGR.
Okay, right. I heard Mr. R. Borpujari, learned counsel for the petitioner, who submits that the petitioner had installed sub-meters in his Hotel Grand Palace, located at BG Road, Jorhat, Assam. The grievance of the petitioner is that there is a mismatch in the readings of the main electricity meter of Hotel Grand Palace vis-a-vis the sub-meters that have been installed therein. He submits that despite various representations to the authorities for verifying the mismatch in the electrical readings, comma, electricity readings, comma, electricity meter readings, comma, the respondents have not acted upon the petitioner's application still. Okay. Mr. K.P. Pathak, learned counsel for the APDCL, on the other hand, submit that in respect of matters relating to complaints regarding meter readings and billing and electricity bills, comma, there is an efficacious alternative remedy available in terms of the Assam Electricity Regulatory Commission bracket redressal of consumer grievances bracket close regulations, comma 2022, hereinafter referred to as the 2022 regulations. He submits that in terms of the above regulations 2022, the petitioner can approach the Consumer Grievance Redressal Forum bracket CGRF with regard to his grievance, and the same would be decided by the concerned authority. Next para, in view of the fact that there is an alternative remedy available in terms of the 2022 regulations, comma, this court is of the view that the petitioner should approach the concerned CGRF, who should thereafter look into the petitioner's grievance at the earliest. The writ petition is accordingly disposed of. Deeply. What to do, madam?
Some notice may be issued. We need to file application.
Yeah, for whom?
Lordship, I'm for 8 and 9, Lordship, Brahmaputra Board and Jal Sapurna.
Okay, you're the important one.
Lordship.
Okay, right. Mr. Yeah? S.M. Barwa, learned counsel for the petitioner, submits that the petitioner's contractual bill amounting contractual dues amounting to 7,83,894 has not been paid. Issue notice returnable in 4 weeks. Ms. D. Jain accepts notice on behalf of
Water Resource Department.
Water Resource Department, while Mrs.
M. Burman on behalf of Mrs. A. Gayan,
Ms. M. Barman on behalf of Ms. A. Gayan accepts notice on behalf of response number
8 and 9.
8 and 9. Ms.
Behalf of AG, respondent 10.
Your name,
Bhakti Talukdar, Lordship, mentioned is in.
Mr. R.K. Talukdar accept notice on behalf of response number 10. List the matter after 4 weeks to enable the respondents to file their affidavit.
Right.
In this case, the petitioner is a registered contractor of the Guwahati Municipal Corporation. His work order was arbitrarily terminated, my lord. And can he file?
When was his work terminated?
His work was terminated on, my lord, this case was, this case is filed taking payment for work, the works done prior to the issuance of the termination order, my lord.
Page 34.
Page 34. This is the second time.
Second.
My lord, previously he filed a writ petition where it was directed that the respondents should undertake a joint verification exercise. And after completion of the verification exercise, it was directed that the payment, whatever
Should be made.
should be paid to the petitioner, my lord. However, my lord, that was not followed because because the order was not
Communicated.
not practicably because my lord,
Well, the order was what? Not practicable?
because compliance of the order was not feasible, my lord. Because in that order, the order was directed to
Verify.
verify what work has been done prior to termination of the work order, my lord. But cleaning of my lord, his work was related to cleaning and desiltation of drains, my lord, in Guwahati city. The cleaning and desiltation of the drain is an ongoing process, my lord. And sea level of drains rises after each rain.
Then if it cannot be verified, then how is it possible to quantify what is payable to you?
My lord, in my so-called notice, there's a reference of the divisional engineer's report, where it was indicated that I had completed 25 to 30% of work prior to my issuance of my termination order. At least I have completed 25 to 30% work as per the report of the divisional engineer, my lord. Therefore, I shall be paid for completed part of work, my lord. And similar order was passed in a.
No, no, Mr. Council, you see. Now that issue has gone.
My lord.
That, because is it that divisional engineer's order regarding you completing 25 to 30% of the work, has it been made, that order has been made subsequent to the order passed by this court or prior to?
Prior to my.
Prior to. If it's prior to, then this order is final as on date. Now this order says that the verification has to be done. We cannot go back to a place which is anti the order, prior to the order. So we have to follow this order. Now, if you are not happy with this order, you can go in review against that order, or you go in appeal. But before, if you come to this court, I am a single bench like this, the coordinate bench. I cannot go beyond this order.
My lord, can it direct him to pay for the completed part of the work, my lord, as it was done in a similarly.
Mr. Counsel, look. It says here, after such verifications, the payment be made. Now, I cannot say that you pay them as per the earlier assessment apparently made by the divisional engineer, because that issue has already been looked into while passing this order in the year 2022. So if you want this order to be modified, then you go in review against that to the same judge.
And you have not preferred contempt also.
They don't prefer contempt. That's a different thing. That's a different thing. You see, maybe too late.
Too late.
But the only thing is that what I can do is I can pass the same order. That's all. Not a different order, which is not in consonance with this earlier order. I can pass the same order, because if you say that you have missed out on going to the contempt proceedings, that I can do. But I'm not going to pass I'm not an appellate authority or a reviewing authority who can change the earlier order pass.
Kindly pass the same order, because the filing of the limitation period for filing contempt case is over. My lord.
Correct.
That's right.
Only that can be done. But why are you not verifying?
That contempt case is filed and then
Huh?
and
Contempt case is filed?
contempt case is filed against few person, not this person, few other persons who are in the argument. Contempt case is filed, and one of the contempt cases where affidavit has been filed, because this is the issue is of 2021.
Correct.
Measurement, a part of measurement has been re-verification cannot be done, because once a rain comes,
Correct.
it goes out. So that issue was raised,
And
the court accepted that issue and directed that pay the amount which has been recorded, which has been calculated in the time at that particular time. Accordingly, the contempt was closed. Because once a rain comes, even it's there for
correct.
one-
They cannot be now.
it cannot
That
be
is
done
of
to the person who
2021
wants to-
also. 2021.
Because he has missed out in the contempt.
But contempt also could not have done it. I mean, I don't know if it's proper to, in a contempt, whether you can give any observation or direction. That's a different thing.
Well,
But-
an affidavit had to be filed saying that this is the calculation he is entitled to about the regarding the.
Why don't you file a review or something before the same court?
More than 1 year has passed, my lord.
How does it matter?
Review he can file. There is no.
I don't think he'll seriously object to the review.
Similar order has been satisfied. If necessary, we will come again filing a contempt case.
Because he has missed the period, limitation period has gone. That's why the petition is filed. In the
Correct,
meantime,
correct.
some other person. has got the order.
Let us, okay, right. Heard, Mr.
Yes, because
S. Bikash, learned counsel for the petitioner. Who submits that that the petitioner had been awarded the contract work for cleaning, desilting and maintenance of all city drains in Guwahati city for the year 2020-2021 by the Guwahati Municipal Corporation (GMC) along with other contractors, wide 71 packages pertaining to different locations in Guwahati. Also, though the petitioner had started the desilting work in terms of the contract, the contract work was terminated by the respondent authority prior to the work being completed. The petitioner being agreed by not being given his contractual dues had filed WPC 3397 of 2021 along with another contractor. No, that's all. That's all. Don't say along with. Full stop. As similar as another writ petition, as a similar writ petition had been filed by another contractor, that is WPC 3164 of 2021, this court disposed of WPC 3164 of 2021 and 3397 of 2021 by the common order dated 2012-2022 by directing the respondent authorities to undertake a verification exercise of the work done by the petitioner by including the measurements of the work done. This court also directed that payments should thereafter be made on the basis of the verification made by the authorities, which should be done in the presence of the petitioner or his representative. Full stop. Next paragraph. The petitioner's counsel submits that the state respondents have not complied with the direction passed by this court in WPC 3397 of 2021 till date, and that the petitioner has not filed any contempt petition due to non-compliance of the direction as the limitation period has expired. Full stop. Next paragraph. On considering the fact that next. Mr. S. Bora, the learned counsel for the GMC, submits that similarly placed persons as the petitioner had filed contempt petitions for non-compliance with the direction of this court for verification of the contract work done and payment to be made. He submits that as verification was not possible due to a flux of time and the fact that the monsoon occurred every year, the contempt petitions had been closed with the direction by the court to pay to the petitioners therein the contractual dues for the work already done and recorded by the authorities. I have heard the learned counsel for the party.
Here I want to add something.
Huh?
There are one contempt petition is disposal and another contempt petition is still pending.
What is the contempt petition that is disposed?
Well, let's say we come to page number 44. One contempt case now 145 of 2020.
Contempt number 145 of 2023, huh? That disposed of, huh? Yeah. On considering the fact that no, next part. I have heard the learned cause for the party. The direction passed by this court in WPC 3164 of 2021 and 3397 of 2021. While order dated 2012-2022 is as follows. Page 43 from here to here, okay, red to red. Next paragraph. The petitioner in WPC 3164 of 2021 had filed contempt case C 145 of 2023 for non-compliance with the order passed in WPC 3164 of 2021. Contempt case C 145 of 2023 was disposed of by order dated 9/9/2022. In view of the settlement arrived at between the parties, wherein the GMC had taken a stand that the petitioner would be paid the amount awarded, amount for the contractual amount for completion of 30% of the contract amount. Of the contract, not contract. Next part. On considering the fact that there is nothing reflected here as to the there's nothing admitted here by the GMC as to the amount of contract work completed by the petitioner. Come on. This court is of the view that a similar order that has been passed in WPC 3397 of 2021 should be issued again. Accordingly, in view of the above reasons, the GMC and the only GMC.
So GMC, this is the respondent one is the parent department, government of
The GMC and
the Department of Housing and Urban Affairs.
the
Department
of
Housing Affairs. It's the
Huh?
Housing Affairs.
the Department of
Housing and Urban Affairs. Government of
Housing and Urban Affairs are directed to undertake a verification exercise of the work done by the petitioner. Pertaining to cleaning, desilting and maintenance of all city drains in Guwahati city for the year 2020-2021 and particularly package number C and D/40. Thereafter, payment should be made in terms of the verification made by the authorities in the presence of the petitioner or his representative. Huh?
Difficulty to not be feasible. That's why.
The above is how the above direction would, however, not preclude the respondent authorities from paying to the petitioner the contractual dues in respect of any records or verification made earlier by the respondent authorities with regard to the amount of contract work done by the petitioner, prior to termination of the contract agreement. The entire exercise should be concluded within a period of 3 months from the date of receipt of a certified copy of the sum. The writ petition is accordingly disposed of.
The termination order, that is there, it is there. Third party inspection has been done.
So in the termination order, it is already reflected, I think, 25 to 30%.
Termination, third
That's
party.
why I said that preclusion part you put, because in terms of the contempt,
Problem.
what is this? Who was the talk? Who had made the mention? MK Chaudhary said.
But I don't have objection regarding adjournment. At least I should have.
Correct. No, we,
Take interim order also that.
that will,
extend.
that will extend. TL?
I'll get his name.
You can look at the live streaming and see who said that. And then you can catch him outside. Okay, interim order to continue. In item number 18, interim order to continue. Till the next day. Oh,
Item number 14 also.
what is the matter about?
The petitioner was seeking exemption of the interest. There was an interest subsidy scheme on the education loan which.
Educational loan, that's what I remember.
Which is taken. But the problem is that I was appearing for the erstwhile United Bank of India.
Huh.
Which is no longer there. It has merged with the Punjab National Bank, and the necessary implement application also has to be filed by the petitioners perhaps. But this has not been informed to the court. I have not been informed that they would be seeking time in the morning.
Okay, in that item 18, you write. 14, you write. Mr.
As the
S. Datta has subsequently appeared for the respondent number.
no, I am there for the very
I know, but today,
today,
for
respondent number 2 to 4.
for respondent number 2 to 4, and submits that his consent was not taken prior to adjourning the matter. He also submits that the
United Bank of India.
That the United Bank of India is no longer in existence,
It has merged with the Punjab National.
as the same has merged with the Punjab National Bank. As such, the petitioner would have to implead the Punjab National Bank. That's all.
Another important aspect of the matter is that we had filed the affidavit in opposition in 2019 by placing the facts regarding the interest subsidy which we had actually granted by annexing the
You had granted the subsidy.
subsidy by annexing the ledger accounts. That fact has not been controverted for the last 5 years.
So actually nothing remains.
Actually, nothing remains in the petition. So this whole exercise of impleading Punjab National Bank, that might not be necessary.
Okay, then you also write one thing. The educational subsidy that was applied for by the petitioner had already been granted
Yes,
by the National Bank,
by the erstwhile United Bank of India.
by the erstwhile United Bank of India, and as such, there is nothing to decide. There is nothing left to decide in the writ petition.
It has not been controverted.
In as much as the said statement made by the bank in their affidavit has not been in their affidavit at para.
In our affidavit, we have stated this in paragraph 7 and paragraph 9.
At paragraph 7 and 9 have not been controverted. So stop. Then they said list the matter when? After 2 weeks. Give a date. 17th.
December.
18th. You'll be there on 18th, we'll close it.
Supplementary motion 45.
Forty-six, which will cover 45. Will cover 45.
This 45 and 46 is same contract or different contract?
But the issue is the same. Well, I'll give certain list of dates, subsequent, but I'll tell you what is then it will be easier to the list of dates. My lord, this is about water resources department, where they voted in NIT. For
You did not submit your bank guarantees.
I'll tell you what happened. So NIT was voted, 3 participants in NIT, my lord.
NIT dated?
NIT dated it 14/8/2023. In this, my lord, the petition which your repetition is holding different now. And
46.
yes, and the bid submitted by us is on 6/10/2023.
What did you submit?
Bid
Bid submitted on
on 6/10/2023.
6/10/23. What is the last date of bid?
Last, but no, there is no dispute of all this.
Okay.
That's why I'm not troubling. How many bidders are there? There is no dispute. Now, we emerge as L1. So the minor 18/1/2024, the letter of acceptance. That's very important.
Letter of acceptance dated
Letter of acceptance issued by respondent number 3
on
on 18/1/2024. Right. Now it is a JV minor. JV, joint venture, which we entered in agreement with the JV on 19/1/2024. Now,
you entered JV,
JV joint.
but you said 19/1.
19 was the agreement with the joint venture agreement. Joint venture
After a letter of acceptance, JV was made.
No, that is between in relation of the project. Initially, before that, JV was there, my name. That was there initially.
Okay.
After we have participation was JV.
Okay, participation. Yes.
Yes.
So contract executed with the respondent authorities.
Yes.
Contract was executed with the respondent.
Now the dispute, what your lordship is now about bank guarantee. Now, your lordship will kindly note down that after letter of acceptance is being issued, my lord, on 18/1/2024, any bidder has been secured by our performance security, which is 10% of the contractual value. Now, it is either by way, it is normally by a bank guarantee. Now, we find in clause 47, your lordship will kindly note down, clause 47 is instruction to bidder. In clause 47, we find that it is not only by way of a bank guarantee, it is in any other form, a bank performance security, you can secure.
Let us see page.
This is page 82. 82. Kindly see 47, performance security. Within 28 days of receipt of notification award for the purchaser, successful bidders shall furnish the performance security in accordance with the GCB general.
Included in section 9.
I'm sorry.
No, included in section 9.
So you all lordship is looking into 6344. 6344.
You said the item 46. Yes, 60. Yeah.
Yes. See page 82.
82 I've seen.
Clause 47, performance security. Now within.
Included in section 9. Included in
Yes.
section 9. What is this section 9?
Contract form.
Let us see.
This is a format.
Let us see.
Yes. One 68. 172 is relevant.
Section 9 contract form.
172.
Performance security 9-5.
160, section 9, contract form. Okay, got it. Please turn to 172. License rate, agree. Okay, got it.
Performance security, yes.
This is the form. So I am the enter the contract for occupation of 2020. So now, people lordship now,
Just a minute.
Yeah.
Just a minute. Where does it say performance security shall be bank guarantee?
this is always, normally it's a bank guarantee.
No.
That's what,
No,
Say,
normally though I know, but then you see the reason is
yes,
you said that it will be a bank guarantee or any other form.
That's-
So where does it say that?
the 80, same 80 your lordship has to read. fast.
It says acceptable to the purchaser.
No, or another, they have accepted. That's why I'm saying.
Acceptable to the
They
purchaser.
accepted. That's
Correct.
no quarrel. They accepted. That's why I'm saying, my lord.
Okay.
They have
So
accepted.
it's a bank guarantee.
My lord, what it is, if on a performance security, the party normally gives a PG or another form that has to be accepted by the department.
Correct.
We say have accepted.
So
There is
out
no quarrel about
in your case, you have given a bank guarantee.
You have given a performance security by way of a fixed deposit, not another form, not a BG. Not a BG. Because 47 says performance security is way of, or normally it's by a BG because you have to guarantee. Secure debt or another form is what is a fixed deposit. But
Fixed deposit, I think you gave, at the time of submission of tender, you must have given fixed deposit.
no, I cannot give
So-
at the time.
So at the time of tender, you don't have to give anything.
It's not.
No earnest money, no
No,
security
it's
deposit,
nothing.
nothing.
That's a different altogether again. But when my lord tender is participate, when a LOA is issued, then the question, because in the LOA, there is a written by them. If you see the LOA, kindly see the LOA. 174, kindly see the LOA. See 174. 18/1/2023. Second paragraph, kindly see, you are requested to furnish a performance security at the 10% of contract amount amounting to so and so, and an additional performance security contract amount amounting to so and so. Now, failure to submit so and so contract shall consider sufficient ground for annulment of the award. So there is no dispute because in 49, 47 says or another form, any or other form, another form. There is no dispute on this, man. They have accepted, I sold it later. Now, my lord, they accepted.
No, you see, performance security is given after LOA is issued.
LOA issued and suppose
When was the fixed deposit issued?
a fixed deposit was issued, my lord. 20. $175.
Huh?
175. Next page.
27 March.
175, 27 March. 2000.
To the submission of.
You require to kindly issue a formal contract agreement and it's the my last. By so and so. Deposit account for a period of 24 months, local body. So and so, we would request you to kindly issue as a formal contract agreement for signing and complying with other documents required. So there was, so they accepted, and there was an agreement which was signed by both the parties.
Agreement signed when?
My lord, will kindly see at page 177. It was signed on 9th of April 2024 at page 177. 177. Not good. 9th of April. 2024. Now, my lord. Now there is, now your lordship will kindly note the date. Now the dates become very important. After that, P7, lordship will kindly note down P7, 2024. My lord, one thing your lordship will please keep in mind. We have written, there is a letter which has been written on a particular super that has been issued to us. Now we have written that entire company they were restructuring the entire company. So there was a problem restructuring the company. So on 3/7/2024, my lord, we have sent a mail to the department for submitting a bank guarantee as replacement of FD, which your lordship will find at page 179. See 179. That is 3rd of July, right? 3rd of July 2024. Lordship will kindly mark it. See, my lord, dear sir, here with two numbers of digits so and so for an amount, because that is why I'm saying please take up this case, which will cover that case also, which is, because there are two, same, my lord, package is different, but the work is same. Now, these kindly here are two numbers of BG bearing numbers 748 last digit and bearing number 749, amount of 2 crores so and so and 2 crores. This again the performance security above mentioned scheme as replacement of the earlier submitted fixed deposit receipt. Now kindly see last. This is important. The hard copy of the same will be deposited at your good office within next 2 days. So hereby we request your good sir to process for the confirmation of the said BG from the issuing bank on the basis of this mail, which may help to speed up the process. So this is what we have asked for, replacement, which was given by a fixed deposit in these two packages. And this particular letter was sent to them. And the BG which was submitted in a page 181. We submitted the BG and
You submitted the BG when?
on 29/6/2020. 3/7/2024 we submitted.
3/7/24 is your letter.
Letter with
And you have paid for 2 days in your letter.
hard copies. Hard copies.
Huh?
Hard copies we said.
Hard copies of the BG.
Yes, but we are having two numbers of BG amounting to and so again about this.
Hard copies are the main thing.
Whatever we submitted, there is no quarrel on this submission.
When did you submit?
Within the time period, not 2 days within that.
No, that. You see, because you have asked that you have asked for 2 days time to submit your BGs. By letter dated 3rd July. 3rd July is at 179.
180 is the attention of the bank guarantee. 180.
180.
180.
Attachment of bank guarantee. These are all just soft copies. These are not. These are by email.
Yes.
It is the number.
There is no quarrel on this subject.
Okay.
There is no quarrel. The quarrel is something else. I am showing it. And to the point, I will show it back. Whichever it goes against me, I will tell you lordship. I will not give anything which goes, this will go against me. I will point out before it. And how to give an answer also, I will tell you lordship. Now, this has been given. Now, which is most important is they have returned the fixed deposit at page 184. Kindly see 184 dated 77/2024. Now,
Yes.
They returned on 17/7/2024. Your lordship will kindly note it. They verified the bank guarantee. They confirmed the bank guarantees after verification, and thereafter they have returned the fixed deposit. That return of the fixed deposit is at page 184, right? 184, which is dated 17/7/2024. Lordship got it, fine.
Yes.
Now, here is the letter which 187 your lordship will kindly mark it. This is the problem when it started, 187. This is the problem. 1st of August 2022. You should got it, Mike.
Yes.
Now, see kindly, subject regarding bank guarantee submitted by your performance in lieu of fixed deposit against the contract, so and so, so and so, so and so. Now, see, para 2. Thereafter, we received a request from you. No, kindly see one. 2 contracts, supply of your textile, so and so, so and so. That is 2 contracts. That is item number 1. This is what is that? 40, 45. So and so, package number so and so. Now you kindly see 2. Thereafter, we received a request from your mail dated 3rd of August, 3rd July 2024, which I have looked into, to replace the fixed deposit with bank guarantees. And on 5th of July 2024, we received 2 bank guarantees from you against the 2 contracts as like this number 748, the last digit, 3 digits, and 749 for an amount of so and so, so and so. Issued by Kiran England, manager, Bank of India, as the name of the contract in the BG submitted against package 01A was incorrect, the first BG was returned to you. So, my lord, item number 44, that bank guarantee that said that it was incorrect, so BG was returned. Now, 3 is very important. Your lordship will kindly note down 3. For the BG submitted against package G02, which is your lordship holding it, that is the bank guarantee 3 digits, 749, dated 29/6/2024. As per official procedures, a mail was sent to the bank on 5th of July 2024, requesting to confirm the authenticity of the BG, and in reply, a confirmatory email dated 11th of July 2024 from so and so, from the email ID number was received, confirming that the BG has been issued by the bank. After receipt of this confirmation, on approval, the fixed deposit submitted against package G02 lot number 4 was released to you on 19th of July 2024. So there are 2 things, my lord, if you read para 2 and 3, there are 2 BGs which was given in respect of 2 packages. Now in view 2 packages, 1 package they found that name was incorrect. So they returned and said you correct the name. And paragraph 3 says, so your lordship is holding this brief, this case. This they said that this BG was sent and they verified the authenticity and they confirmed. Only on confirmation they have returned the fixed deposit. Now my lord will kindly see paragraph 4. Thereafter, now my lord will, on 19th of July 2024, we received a BG dated so and so for contract package G018 with the name of the contract corrected, which was issued by so and so. Mail was again sent to the bank on 24th of July to confirm us about the authenticity of the same. So again, where they say in paragraph 2, you have to correct it, we corrected and have sent back to them.
Yes, sir. You sent a different BG number.
For it, that is item 44. Item 44. 2 bank guarantees.
There is no item 44. You've got item 45, 46, 47.
45.
Huh? No, you see. Come to para 2.
So this was a fresh bank guarantee. I have taken fresh bank guarantee as a replacement of the earlier.
So you have replaced 48 with,
correct.
you have replaced 48 with 62.
Correct, absolutely correct. Has to be correct. Because it is not correct name, that's why we have to replace by a fresh bank guarantee. Now, if your lordship see 5, this your lordship will kindly mark this 5. 5. In reply to this, we are surprised to receive a mail from the Chief Manager Credit Department, Mumbai, 26th of July 2024, stating they have not issued any bank guarantees pertaining to number so and so 762 or dated 18/7/2024. He has also stated BG number dated 749 dated 29/6/2024, which was submitted by you against package number and against which we have received a confirmed mail from so and so, is also not authenticated and has not been issued by the bank so and so. Now can we see last? So what they said, my lord, the 2 bank guarantees, one bank guarantee in paragraph 2 said that one guarantee, please correct it and send back to us. One bank guarantee in item number which your lordship is holding, G02 lot number 4, they said we have confirmed. After confirming it, my lord, the bank guarantee has been checked, it has been confirmed, and they have returned the big deposit. Now, they said at paragraph 5 we verified again, and we found 2 things. We found that the bank guarantee which was given in both the BGs, that we find that there are problems, this is not an authentic bank guarantee. My lord, thereafter kindly see what, in view of the above, matter has been viewed, atmosphere and being taken up higher authorities for further action as per official procedure and contract terms. However, we would like to give you the opportunity to intimate us, do you have to say regarding, so please send us your reply urgently within 2 days of receipt of this letter. This is on 1st of August 2024. Now we replied at page on 3rd of August 2024 at page 189. Now your lordship will kindly note one thing before I give a reply to this 189 and also the proposition. On what condition? Impute termination order that I will show it. My lord, your lordship will keep in mind that this fixed deposit is lying with them. Fixed deposit. They never returned the fixed deposit. It was with them only. In this 02, this your lordship is holding an G01, that is item number 45, they kept all together with them. Throughout, they have not returned. It is secured with them. Now, my lord, we replied at page 189. At paragraph 3, we replied back to them. You will recall, my lord, you will recall that block order against which these BGs were submitted required us to submit the performance guarantees for the relevant orders by your bank guarantee only. And we have sought a special permission to submit the performance guarantee by your FDR because our company Flexitar Ventures Inter Limited was undergoing restructuring and a new company, Flexitar Technology International Limited, was being carved out, the main company. All our bank facilities were temporarily suspended because of the exercise. That restructuring has since completed and all our banking systems restructured into the aforesaid company are in process of getting this again. Since a new non-fund limit is in the process of sanction from the Bank of India, our consultant, who is facilitating the release of this limit from the said bank, offered to us that we have handed up the original paper, the corporate security, and the margin for the BG value. He could get this BG issued by sanction process was still on. This would have freed up the cash flow of some business students warranted that this proposal be accepted. That is all we did. This is a result of serious investigation on our part that seemed to fulfill the requirements of collateral and margin money. How could a faulty BG get issued? We have already put our auditors on the job on this fact finding and we shall duly share our finding with you as well. We absolutely understand the authenticity of the submitted bank is immediate. Prime, so we have initiated a step already to the useful. Now, my lord, 190, last paragraph. We are quite sure, last paragraph, we are quite sure that this will clear the doubt based on our integrity. Sir, we are highly respected and decorated company quoted on both Bombay Stock Exchange, National Stock Exchange. We are one of the highly respected and coveted
award for the best export performance from Government of India 22 times in last 22 years without missing a single year. We are not expected to do such irregularities and we undertake and commit that we have not done this. So this is letter which has been sent. Now, my lord, the termination, they have got absolute power to terminate. There is no doubt about it. My lord will kindly see 22. Page 22 is termination. But which will be effective from 30th of this month, 30/11/2024. Kindly see at page 22, termination. What you got it? Please, please.
Yes.
See page 22, 16/11/2024. We are writing to formally notify you of the termination of a contract dated 9th of April 2024 under reference according to provision set forth in clause number 3 and 35(1)(a) 3 of general condition of contract pertaining to contract package G02 lot number 4. Please mark my lord one thing, clause number 3 is at page 149. Your lordship will kindly mark that. Clause number 3 is page 149 and clause number 35.1(a) Roman 3 is page 161. Please mark that one. Clause 3. I'll show that man what is clause that. First your lordship will mark page 149, clause number 3 and 35(1)(a) Roman 3 is page 161. Now, kindly see, second paragraph is very important. This termination is prompted by a thorough investigation into validity of the performance bank guarantee, namely so and so, submitted by you as replacement against the term fixed deposit. It has determined validity of PPG could not be established. Subsequent this matter was referred to the funding agency, Asian Development Bank, which has corroborated our decision to terminate the contract for aforementioned reason. In accordance with the agreement, required notice period is 14 days. Therefore, the effective termination date will be 13th November 2024. We kindly request the answering matter so and so. Now, my lord, will kindly look into it. The provision of 149. The first termination, which is correlated with the clause 3. Termination, you know, 161. Page 161.
Yes.
35. Termination 35(1)(a) Roman 3, which they have invoked. What you got it? Now, may I read that? The purchaser without A, without prejudice to any other remedy for breach of contract by notice of default sent to the supplier may terminate the contract in whole or in part. Either they can part or they can whole also. Now, 3 is important. If the supplier, in the judgment of the purchaser, has engaged in integrity violation as defined in GC clause 3 in competing for or in executing the contract. Now here, what I will say, I will take to your lordship that integrity violation, what is integrity violation? But while the purchaser takes a decision, writes a judgment on the basis of the material which are available, my lord, before that, my respectful submission will be that when you issue a termination order, when you invoke this 2 clause, a original opportunity should have been given to you, which has not been done in the instant case. My lord, I am saying today also, they have got every right to terminate. Only after hearing me, they have got right to terminate. They cannot take a few, my lord, a judgment, terminate by taking a judgment without hearing the other side.
They can give you a post-decisional hearing order.
No. Effect of termination is there. What is the effect of termination? That your lordship will find the effect of termination.
You see, one
No,
thing
what I-
is, just a minute, one thing is, your BG, the bank has said that it has not issued.
But that is, how can you do it? No, how you say? Because one said in paragraph 3, on that one, they said, you have issued, we have checked the authenticity.
Have you got any document here
Yes.
from the bank saying that what has been said by the petition, by the respondent authorities is wrong. Have you got any document here stating, the bank stating that what the respondent authorities have said is wrong?
So what we want.
Is the issue, did the bank issue any bank guarantee? That is the issue. Now, if you, now so what is the show cause going to be? The show cause, even if it is sent to you, is going to be whether the bank guarantee was issued by the bank or not. Now, do you have any document in your possession to the effect that the bank has stated that yes, we have issued the bank guarantee?
But paragraph 3, they have stated themselves.
Who has said?
Yes, the department has written, paragraph 3 kindly. see
But
what
that
it
was
says.
that, no, they can always re-verify. There's no,
That's not what, no, they have verified and they have authenticity, but they confirm it thereafter, my lord, they release my, the fixed deposit at paragraph 3, kindly see my lord.
but later on they came, you see, just
No, no,
sometimes it happens that
My lord,
sometimes we do not, sometimes you
no,
see.
your lordship has followed what your lordship is right. But what I'm saying, when you have taken an action at page 22, and you said a thorough investigation for validity of performance, bank guarantees, my lord, should you have, you should have given the report. What is the report? That report is not before us. Any action taken, the report has to be furnished. We'll give a reply to it, my lord.
Anyway, this is with regard
No, I'm
to
not
supply.
saying, my lord, what I'm saying today, my lord, it's terminal. It will go to terminal 30. What I'm saying, 30 level. Let them take instruction on this particular, on this issue. One. Number two, my lord, they will come up before the court and say about what termination. Our whole case is that you terminate, our principle of natural justice has not been followed. That's a point. Point A. Point B. Your lordship has asked number post the issue. Now there has a consequential to that. Your lordship will kindly see how they can do it. If it after termination, the effect is find that 35 A B, kindly see B. You
Page,
terminate at page 161. That's what I'm worrying about.
yes,
But today, now before that, kindly see my lord, in the event the party with purchase terminates the contract in whole or in part, person to GC.
no, you see, out here, we will ask them to obtain instructions, but you have to also obtain instructions.
Right. Well, what I'm saying.
It has to be
Your
both ways.
lordship, I understand fully your lordship. I have understood your lordship. Now the problem is that your lordship, my integrity, bona fide from the very beginning, if I have to deceive them, initially bank guarantee would have been, I would have given bank guarantee. Why I have given a fixed deposit? Till today, it is being secured. They have that fixed deposit. But till today, if I have some intention, I would have defraud them on the very first instance, my lord.
No, might not be. First, you've got to take their trust.
No, kindly see, my lord, no, if that be the case, then the fixed deposit, I will take out the fixed deposit. It is with them till today.
We will see. No, anyway, but you see, the issue is this. The issue is whether the bank guarantee is a fake or not. That's all.
And no.
That is the main
No,
thing.
that's not only the issue, my lord.
Others will come.
Yes.
But the main thing is whether bank guarantee is fake or not.
Well, let us say that they produce these are, but whether I'm not entitled to get a notice before you terminate, this is a big project, 25 crore.
You see-
That, my lord, there may be not an inbuilt mechanism. There are judgments which are shown. Any type of case, my lord, where the civil consequences, public element of.
No, that is there. That is there.
That's what I'm asking.
No, but
I'm not asking more of it. I'm not troubling your lordship more of it. What I'm saying, before we great respect before your lordship, is that please give me an opportunity before taking an action. I told your lordship that they have got every right to terminate. No one can deny that. But before terminating, please give an opportunity, give the report to us so that we can look into it. What is the report? But am I not entitled?
no, that is there. No doubt.
That's what
But
I'm
you
saying.
already know the story.
Yes.
You know why you have been terminated. So you know that the reason is.
What I'm saying.
No, just a minute.
Yes.
Just a minute. You know that the reason of your termination is the bank statement that, alleged bank statement, that they did not issue those BGs. Now, to prove that those banks, their bank BGs were issued by them, you'll have to go to the bank and find out whether the statement that has been stated by the respondents in their letter is correct or not. So that the bank, you can always go to the bank and tell them that this is right or wrong.
But when the department is alleging on the basis of an information which they gathered, while you before issuing a termination order, you could have given a so-called, we are, they could, we are invoking a so-called under this.
Anyway,
Which they have not done.
we will issue notice, that's all, nothing.
I'm just praying. I'm not asking to stay this termination. Let me be very honest to you.
Yeah.
I know my limitation. I know I have also practiced. I know my God. I know what your lordship on the other side. I know what happens by because it will going to terminate. What I'm saying, this package. Forget about the third package. That other one more case. I know trouble. That is an annulment that will be kept aside because this is a contract which is entered between the parties, and there is entered and supply has been made in respect of item number 40.
7.
40,
What?
45, I think. What's that?
Right now, we are
45.
dealing with 45, 46, and 47.
Yes, 45, we have supplied. That's the whole issue, my lord. We have supplied.
They supply the entire, full,
Yes,
fully.
So I'm not saying terminate. I'm simply praying before logic that status quo has to regard to the package. Which package it will be.
No, if you have supplied supplied the entire material in respect of 45. Huh?
Supply.
Yes, sir. No, we'll see.
No, what I
This is a very, because this is a very serious issue.
no, what I
Bank guarantee, fake bank guarantee.
I'm not saying for stay. What I'm saying, please maintain a status quo in respect of these two packages.
We'll see.
Short day, you're watching
No,
a short day. And please maintain, because otherwise tomorrow they floated tender. And tomorrow if your logic finds, then absolutely it is that they could not justify it. Or that the principle of action just has to be followed. Then
Damages are there.
no, my
Damages.
your logical damages is something else where we invested so much of money in this case. And today, my lord, it is being secured by your fixed deposit is lying with them. If my intention was bad, I could have taken away that fixed deposit. It is lying with them. So only my humble request before your lordship that I am not asking for stay of this termination. Please, my lord, status quo in respect of these two packages only can be maintained, my lord. Only two packages, not in respect of other items.
What is the third item? What is it about?
There is no contract which has not been. Is there annulment there? They have annulled.
They have cancelled the tender.
Yes, that's why I'm not troubling. They have cancelled the annual. They have annulled. So I'm just keeping aside. That's why I'm not troubling your lordship. Let it be kept aside. These two I'm saying, my lord, only to the extent, keep a short date, my lord. Keep a short date because the difference amount will be very heavy to us, my lord. And at least, my lord, that a principle of natural justice should have.
They're very serious, very serious.
My lord,
Very serious. Bank guarantee for fake bank guarantee.
but they have done for one, my lord.
We'll clarify that. That will be clarified. You can always go to the bank today or tomorrow, and they can also go to the bank today and tomorrow. We'll direct both of you. Both of you will obtain instructions. And if it is a fact that it is a bank fake, then end of the matter.
But before terminating.
No.
before-
But we let the bank clarify that. Who will be the best
No, I
authority?
understand.
Huh.
But can you take a unilateral?
No, just let me ask.
Keep aside, your lordship is right.
Hmm.
Your lordship is absolutely right.
Uh,
But can you take a unilateral decision?
Correct. You should,
Principle of natural justice is not
no,
there.
that is there, but that is there. But then the issue is this, when you knew that you have been, supposing you have been made a scapegoat due to a false allegation, then you could have easily taken steps to counter that false allegation, which you have not done. Instead, you have come to this court saying that violation of principles of natural justice.
Come directly. We have given a reply to them.
Hmm.
On a so far we have replied, but their reply, what you see there, my reply, if they doesn't speak anything of my reply, just straight away 22. That's my case, my lord.
No, let us, yes.
My lord, supers have been, there has been what supers they have said, this is what, they could have said that we have investigation has been made, They have not done anything. My reply, where is that answer to my?
No, your argument is all right. It is all okay. But there is, that part is all right.
No, my-
That no notice, all right. But the thing is that you also could have done it, clarified the issue.
No, what? No, only 2 days. They have given 2 days. How can in 2 days they have given? Only?
So we'll ask, we'll see.
2 days. But till then, my lord, this only in respect of two packages.
Has the bank been made a party here?
Lord,
Has the bank been made a party? Because the bank is the one who has said that they have not issued the bank guarantee. The bank should be made a party. They would have, they are the ones to clarify the issue.
I understand. What the lordship has, but the view is that, but 2 days time it can, 2 days time was given to us. How
Yes.
it can be done?
No, but in this writ petition, you could have made the bank a party. Then we could have easily directed the bank, okay, did you issue this bank guarantee or
No
not?
problem, my lord. Not making a party, there is no problem. What I am saying, we are only agreeing on your action taken without giving any notice to us. My lord, that principle of natural justice, my lord, they want to stay away that principle of natural justice, that principle, my lord.
Anyway,
My lord, all actions, there may bigger or lesser action taken by any authority is, my lord, public element of law is involved. Civil consequences are there, my lord. So any action taken by them, it always has to preceded by a notice. That is there, my lord. Principle of natural justice has been followed. After that, we don't have any regret. After that, my lord, kindly see at page 22, they said we made a thorough investigation. What thorough? Can you, why you have not provided with the report? Single 4 line is not enough. 4 line is not enough. If an investigation is being made, why you have not given the report? That this investigation has been made.
okay, now let me hear us.
May I please, your lordship, we have given notice on 16/11/2024, your lordship, giving him 14 days time for reply, your lordship. Secondly, your lordship, we have issued email on 31.
16/11/24.
24, they take the impugned notice, your lordship. And your lordship,
Page.
page number 22, your lordship. We have given 14 days time to him for reply, your lordship. Secondly, your lordship, we have issued email dated 31/8/2024.
Email dated 31.
I am placing a 31/8/2024, your lordship. On that email, we have requested them to take back his fixed deposit, your lordship, which he has not taken till date, your lordship. And lordship, we have verified, physically verified the bank guarantee, your lordship. And bank has in their seal and signature stated that the BG has not issued by them.
That is again page. Is it here? Not here.
This is the report, your lordship.
Let me see the bank report.
Lordship, this is,
The bank should be made a party also.
It's a breach of contract, your lordship.
Ah?
It's a case of breach of contract, your lordship. And as per the general condition of contract, we are going to terminate him, your lordship, within 14 days time, your lordship.
Fixed bank guarantee.
Kindly give us some time and we'll file affidavit, your lordship, but no stay, no status to your lordship.
Okay.
This, we should also get a copy. This is.
Yes, you give a copy.
Doesn't give it, now they're giving the code. They should have given before taking an action.
They should have.
Then that's the whole case, my lord.
No, but anyway, this is a, whatever it is, whatever has happened, this is a issue of a fake bank guarantee, and this is, you see, the bank also should be made a party here, and then we can then let them file affidavit. They'll clear it up in 1 minute. They'll clear up.
Subject to your matter of right. We are not asking for stay of establishment. It is going to happen tomorrow. One. Number two, only troubling your lodging till we get the report and we just make your party back. We'll see my lord by taking it. Till then, the status quo in respect of these two petitions. Otherwise, the whole case, it will be.
No.
But then, my lord, I have to take up. It so happened that nothing remains in the case. Nothing remains. That's it.
This is a very serious issue.
No, that is the academic discussion.
Actually, when there is,
My lord, with my experience, I have seen bank guarantees also are issued so many cases, but at least a chance is given by the court.
no.
To clear up, only a natural justice, that my lord has to be followed. That's the view of all the courts, my lord.
we
It's a
can,
very serious
we,
case.
yes, when,
Very serious case
you see,
also.
when this report is there of the bank, when the bank report is there, then we can always ask you to make a reply on this.
But my lord, your lordship will
You
ask.
see, yeah,
That will have replied, and my lord, there is no status quo, then my lord, it will be like an academic.
actually, but
Academic.
what to
What
do?
will be the use, my lord?
But what to do? This is a crime.
My lord, termination, I'm not.
This is a crime, in fact, a very serious crime.
My lord, that will be only happen. And every serious crime, my lord, a charge sheet is being filed, a person is given liberty. Then ultimately, end of the day, he may be convicted or acquitted.
Correct.
So that's what is happening, my lord. It's a their side. At least I think you must in the thorough investigation. Am I
Not in this case. Not in this case.
My lord,
I'm
that's
sorry.
what I don't know, my lord. I don't want to academic and waste your lordship valuable time by next coming and arguing this matter. A principle of nature, your lordship is satisfied. Then your lordship will say.
You see, we can always, we can decide this matter by next week. It is not that, no need of giving status quo for 2-3 days. Nothing will happen on Saturday, Sunday.
That is reflect, my lord.
No, we can always correct the whatever. If this is a wrong fact.
My lord, it is very difficult, my lord. With great respect, I am saying.
No, I'm sorry.
If there is no order, my lord, then there is no point, my lord.
No,
I am not asking for stay of determination. Your lordship will kindly look into it.
No.
But for the very first time saying, don't stay this.
We'll direct them to give it to you a copy.
I give your lordship. Now, just now I will give your lordship.
You give a copy.
But no status for your
Well,
lordship.
let's say sick time. If that I told my lord, I don't want to unnecessarily trouble your lordship with academic discussion. I'll withdraw it then, my lord. If that be the case, I will.
No.
But natural justice has to be followed. They didn't follow it. That's my case, my lord. Any serious case, my lord.
Maybe, but then you see.
Maybe, my lord.
No, you see, post-decisional notice can also be given.
But what Supreme Court said, while just in 2023, 6 SCC, my lord, will kindly see what great repercussion will be there. Maybe the biggest crime you want to do it. But the principle of natural justice, kindly see.
When someone does a crime, no one gives him a notice. IPC, okay, you have committed a murder. Here's your notice. Please reply to this. Nothing. This is a crime. You have given a false BG.
And will kindly see.
You're giving a false BG. You're cheating. You're cheating people.
There are 40
With a cheating case, no one gives you a notice and says this.
cheating case is always being proved after my. These have been kept secured.
No, not in this case. I don't mind giving stay here where I find it's deserved, but not in this case. Not after I've seen this report.
My lord, they're just asking my client, if possible, then my lord, there is will withdraw it.
Okay.
We'll ask our client.
Huh?
We'll
Yes.
withdraw it.
Okay.
We'll just take an instruction for
Okay.
just pass over.
Okay. For the time being, pass over for the time being.
you know.
Just give me that.
Well, we got instruction, we'll withdraw it.
Okay.
We can liberty to approve before the appropriate.
What a good liberty.
The High Court, I'm not saying High Court. Appropriate court, means there is another forum.
Okay, right. Heard Mr. D. Das, learned senior counsel for the petitioner. Assisted by Mr. Arjun Singh Sujrewala for the petitioner. He pleads that he may be allowed to withdraw the writ petition with liberty to file a fresh before the appropriate forum.
Of place is not in High Court.
Before the appropriate forum. Miss R. Dekha appears for Water Resource Department, while Miss Yudas appears for Respondent Board. Right. The matter pertains to the termination of the petitioner's contract on the ground that the bank guarantees submitted by the petitioner are fake bank guarantees, which has apparently been reflected in the letter dated 1/8/2024 issued by the Chief Engineer, Water Resource Department. Huh?
Subsequently, the bank guarantee, subsequent.
Actually, no, all.
No, not only for, not on the very first instance,
Huh?
subsequent. Subsequently, we have given the bank guarantee, not on the onset. Onset was the fixed deposit. Onset.
No, I'm saying only the bank guarantee. I'm not saying only the bank guarantees. All the three bank guarantees are found to be false.
Which is disputed by.
Anyway, that's I'm just I'm not being any. I'm just stating the facts. No, I'm just stating the facts. That's all. What have I said? Water Source Department, Government of Assam. Full stop. The petitioner's case is that the report on the basis of which submits that the basis for the respondents coming to a finding that the bank guarantees are fake have not been given to the petitioner. As such, the principles of natural justice have been violated. On the other hand, the respondent's case is that the bank has issued letters clarifying that the bank guarantees submitted by the petitioner are fake. The prayer of the petition's counsel is allowed, a writ petition dismissed as withdrawn, with liberty as paid for. Then in the other one also, same in the 45, 46, 47 also. 47 also. 47 that does not is not with regard to fake guarantee, fake guarantee. 47 is different.
Same, annulment is on the same. Same.
On the same ground,
Same.
is it? Okay, did the item 47 you just write? I heard Mr. D. Das, then senior counsel, assisted by so. Ms. R. Dekha, no, he submits that he may be allowed to withdraw the writ petition with liberty to approach the appropriate forum. Ms. R. Dekha appears for the Water Resource Department, while Ms. Yudas appears for point number 1. The matter pertains to the cancellation of the letter of acceptance issued by the respondent. The prayer of the petition's counsel is allowed. Writ petition is dismissed as withdrawn, with liberty as taken. Give it back. And you give them copies.
I'll give.
We will give a copy now.
Yes. You can tell your juniors to have a photo. They can take the photo with their phones.
Just about
Item?
just remember, recollect this case. Because the tender was quoted. By way of an advertisement, NIT at stage 36. For currently that your lordship, the last order kindly see 23/10/2020. That's very clear. See that order. Everything is different. That order is clear.
May I place my instruction in that case? May I place my instruction?
Yes, yes.
Lordship has sought for instruction as to what are the rates in the other medical colleges and
Yes,
hospitals.
yes, yes.
Lordship will see the third page. We have got the entire chart. As on that, 13 medical colleges and hospital are functional. Lordship will see well, GMC it is 167. Tezpur Medical College 130. This is Diffu Medical College 115. Silchar is my lord 135. Dhubri is my lord 147. Lakhimpur is 142. Assam Medical College 120. Jorhat is my lord, Jorhat is 94. It is a fixed my lord. And Borpeta is 73. So Lordship wanted to know how my lord at that point of time we have fixed it 142 for the petitioner my lord. Presently he is supplying my lord in Nalbari. So my instruction says that my lord at that point of time before the recent settlement in Borpeta, there the rate was my lord 142. Since my lord Nalbari is a new institute, new my lord medical college setup. So they took over whatever rate was available, that was rate was furnished to the present petitioner. And he agreed and accordingly at 142 he supplied. But in the subsequent tender, that amount went down to 73. It was a partial tender. And 142 was prior to that matter in Borpeta. I've got the letters also.
No, no. Right now the issue is with regard to
Issue here is my lord, so far as-
Nalbari.
Oh, no, Nalbari, my lord.
Nalbari.
The
Now
tender,
Barpeta is 73.
73, it has been settled, my lord, in last year.
Ah. So,
So, my lord, their tender committees are different. I wanted to show
No,
it's
no.
not that, my lord, everywhere it is 73.
Huh?
In entire state, my lord, it's not that, my lord, it is 73 or, my lord, below 100.
correct, correct. Different.
Majority, my lord, even I would say 90% is, my lord, above 100.
Hmm.
Our contention is this, my lord. So far as the present tender committee of Nalbari Medical College is concerned, their contention is that it should be minimum, at least, my lord, their expectation, it should be 120. They have verified, my lord, and found that this cannot be lower than 120.
But
So
why
far as the
don't
bidders
you,
are
why don't you have a condition? Let him start and then if they find within a month that is not doing it, then you
My lord,
cancel.
that is the decision of the tender committee. If losses find any fault in that, that's a different issue. But there is the decision. I would like to place judgment, my lord, just because he's the lowest bidder, my lord, cannot be, my lord, he has gotten, my lord, some right that, my lord, undefeasible right that, my lord, he should be
No,
allowed
but
to
this
settle.
is the public exchequer's money involved.
Lordship will think about money and, my lord, the patient's, my lord, care.
Correct. No,
We
no.
are interested in that part.
When he said that he can give that same, then you give us, then you give this code, what is the requirement? What are they supposed to provide every day?
Yes, yes, yes. Yes, I can place that. Lordship will see in, it is there in the tender itself, my lord, tender itself. My lord. The chart is there, diet chart.
Page.
Yes, my lord, I will place it. Is a part of the, yes, page, my lord, 48. 47 and 48. The part of the NIT.
This is the
milk
chart.
tea with sugar. Whole biscuit, 200 ml. Biscuit branded, 2 pieces.
Butter, banana, then my lord, lunch, rice, lemon, chapati and all my lord, mutton, 1 day in a week. Fish, so and all my lord. So our my lord assessment is it cannot be my lord below 120. Even my lord, it is only my lord almost half of what we are expecting. 78 or something. Including my lord,
70, around 80,
including
70.
taxes, yes, including taxes. So that's our apprehension. And I would like to place 1 or 2 judgment, my lord. So far as the minutes is concerned, my lord, that lordship will find in our affidavit. Lordship will see that part also, whatever we have explained in the minutes, page 78. 78 is the running page number, part of our affidavit in opposition.
Yes.
Lordship will see, my lord, the last para. Prior to that, is regarding GST and all, my lord, there was some, my lord, discrepancy or disparity in the, my lord, tax rates. So clarification was sought for. No, there is no dispute regarding that. Last para. Tender and Procurement Committee conducted a market survey, local market survey, and also assessed the dietary service providers' existing supply rates in different medical colleges of Assam, and concluded that providing daily hospital diet as per the prescribed daily diet menu is practically not feasible at the quoted base rate of rupees 75.85 by the L1 bidder and so by L2 bidders. These are excluding GST matter. Then Lordship will see page 79. Considering the nutritional requirement of the indoor patients as well as hospital authorities, responsibility to mandatorily provide nutritious diet for proper recovery as per the prescribed diet menu, total tender value was estimated and minimum per patient per day rate was found to be rupees 120. Total tender value clearly reflects the approximate daily rate per patient. However, it has been observed that such quoted low rate, which is about half of the approximate estimated rate, will compromise the food quality and the patient will be deprived of the prescribed diet. In the interest of patient care, the tender so-and-so committee decides to cancel the so-and-so and in order to facilitate the process of retendering with required modification of quoted rate criteria in respect of participating bidders after necessary approval of the competent authority. So this was the decision of the financial committee. I will place 1 or 2 judgment regarding whether we are bound to accept the L1 bidder or be the H1 bidder, considering subject to the tender.
You're not bound to. The issue is this. The issue is this. The issue is that you are saying that they will not get the nutritious food. Now but how do you come to that figure that they will not get? That's what I don't understand. I can understand if you said the per kg cost of apple is this much, bread costs this much, eggs cost this much, and as such, they cannot supply within this.
Dinner.
Your what you will say, you verify them. That is in the term, the inbuilt in the terms and conditions, page 57 of liquidation. Can you see? 57. See 57. Page 57. Monitoring for quality. In case hygienic, proper cooking method, quality of raw material are found to be lacking, or there is delay in service, the authority impose penalty as per the latest penalty charge.
Lordship will see the first one, my lord.
Hence,
Para 1.
Yes, we'll verify.
yes, you will verify.
Verify the quality of food. You verify, and then you see.
My lord,
Without verifying, how can you say? How can you speculate?
see,
I can.
page 118 of the reply, see 118. 118 of the reply which I have given. See 118 and see the diet menu and compare with this, which was quoted 73 miles. Kindly see 118. See the diet chart.
This is for what?
Barpeta is 20 kilometers from Nalbari. Same 2023, 2024. Same department.
Same department, medical,
Same
DMC 168.
No, 1 second.
It's not about distance, 168 in DMC, Same chart.
Well, maybe
So
168.
that's
But
Lordship will, I leave it to your Lordship. I will place 1 or 2 judgment. Lordship will reflect it, whatever Lordship passes.
118, kindly see 118.
Ah.
Page 118.
But my lord, this is the decision of the tendering authority. It cannot be in such manner, it can be, my lord, dealt with by under 226, whether this rate will be viable or not. Lordship can only see that this decision making.
No, but so the decision has to be made on some basis. It's not
That's
that.
what I said, my lord. These are the, my lord, various rates, my lord, in other medical colleges. Only, my lord, referring to, my lord, Borpeta Medical College, which seems to be, my lord, supporting the petitioner's case, they cannot say, my lord. That's why I'm saying, my lord, 168, what is the, my lord, harm in, my lord, in the, of the tender committee, if they decide that quality food should be, my lord, provided to the, my lord, patient. It is up to them to decide whether you would like to have this
No, you see,
this particular rate or not, my lord.
No, you see,
Then, my lord, he, my lord, say that we'll have to accept it because he's a L1 bidder.
No, there is another thing. Say, you see, when there is
Giving it to the L2
when there
bidder,
is an
not the L2.
order made for supply of article, then what happens is the rates are called at what rate can you supply the article? Okay, now out here so the rates are quoted for each material or each article. Out here, nothing is there. They're just saying that no, it cannot be. Out here, yes, it can be. Out here, Barpita, it can be. Out here, it cannot be done.
The committees are different, my lord. The college authorities who consider.
So the basis for coming to that decision, that is all I want. I don't want the decision to, I'm not challenging. I'm not saying anything. What is the basis for them to come to a decision that he will not be able to supply?
My lord,
Is
we
it-
have given, my lord, in the last two paras, my lord, of the
Where?
minutes.
Huh?
Yes.
No. But how did you say? How do you know that? How do you know that apple might be costing 50 rupees a kg? How do you know?
My
Or
lord,
50
no, at least I can say, my lord.
I don't know. I'm just
I'm buying for my kids, my lord.
so at least that thing should be that thing should have that thing should have been there. That thing should have been there. Or is it that is it that bread is costing 500 rupees a loaf or
Well,
something?
my lord, even, my lord, in similar tender, my lord, matters of dietary articles supplied by the Director of Health Services, before this honorable court, even rate was quoted for Horlicks per kilo, 50 rupees, whereas MRP is 110 or so. So this is the, my lord, they want to be L1 somehow. So ultimately, considering the, my lord, patience, my lord, this decision has been taken. One, my lord, 2005-6 SCC, my lord, Lordship will see. Why undefeasible right they don't have, my lord, just because they are L1. Yes, if arbitrarily we are, my lord, rejecting it, then that's a different issue. If Lordship finds that, my lord, we are favoring somebody. Here we have cancelled it. We have not said that the L1 or L2 or L3 will get it. So that right we have. Para 11, my lord, page 147. The main relevant page. The citation is 2005-6 SCC 138.
Para?
Para 11. May I read it, madam?
Yes.
The principles which have to be applied in judicial review of administrative decisions, especially those relating to acceptance of tender and award of contract, have been considered in great detail by three judges bench in Tata Cellular versus Union of India. It was observed that the principle of judicial review would apply to the exercise of contractual powers by the government bodies in order to prevent arbitrariness or favoritism. However, it must be clearly stated that there are inherent limitations in exercise of that power of judicial review. Government is the guardian of the finances of the state. It is expected to protect the financial interests of the state. The right to refuse the lowest or any other tender is always available to the government. But the principle laid down in Article 14 of the Constitution have to be kept in view while accepting or refusing a tender. There can be no question of infringement of Article 14 if the government tries to get the best person or the best quotation. The right to sue cannot be considered to be an arbitrary power. If the power is exercised
No quarrel with that. No quarrel with that.
For any collateral purpose, the exercise of that power will be struck down. So here, my lord, whether there is any malafide on our part or arbitrariness on our part, my lord, in taking this particular decision. And this, my lord, this particular view of the Honorable Supreme Court in this particular case has been further fortified by, my lord, in another case, recent judgment. Just, my lord, 2 lines I will read, my lord. It is 2020-16 SCC 758. 2020-16 SCC 759, sorry, 759. Para 40, just, my lord, 3 line or 4 line para, my lord. Instead, precedent laid down by this court in Master Marine, that is the one that I 2005-6 SCC, illustrates that if a prayer for rebidding on account of a desire to get a better price then involvement of Article 14 of the Constitution would not be made out.
Para?
Para 40, madam. If a prayer for rebidding is on account of a desire to get a better price, then involvement of Article 14 of the Constitution.
So now
Here, they are referring to Borpeta and saying that since Borpeta it is 73, why we should not be allowed? That part cannot be here, my lord. This is a separate tender committee, their own assessment, my lord. Rest I'll leave it to you, my lord. That's the minutes. And affidavit. we are-
where is the minutes of the committee?
Yes, my lord. That 50, my lord, I'm placing. That is a page 83, 78, my lord. 78, my lord, of the affidavit filed by the principal.
Page 78.
Yes, my lord. We don't want to compromise with the, my lord, foods which we should be delivered to the patient. We are not saying that, my lord, somebody will go 400, we will be giving it to them. But minimum, at least considering the other medical colleges, more than 50%, my lord, there is 100.
Can you give me the meeting minutes for Barpeta?
Otherwise, I can, but they are not a party area, no money.
Maybe, but then I want to see how did they say that they can supply at 73?
Lordship passes an
It
order, I can
is the
definitely-
government. At the end of the day, it is the government money.
If Lordship passes an order, I will place the minutes of every my lord tender committee of not only my lord Borpeta, even GMC also, my lord.
Yes.
Yes, Lordship verified, I will definitely place.
Okay. All the, how many?
Lordship will direct the director of medical education to find.
Okay.
Because it will be under his power.
Okay.
Direct
How many medical colleges are there all
13.
over? 13.
No, Lordship will see the chart.
How many have you given out here?
Yes, Lordship will see the chart at page 3.
Page?
Page number 3 of that, of the bunch of instruction that I have furnished.
Okay, 13.
13, my lord, but here Nagaon, my lord, they are only considering the rate by as on date, my lord. There is no, my lord, settlement as on date, but they are relying upon the rate of, my lord, Tezpur Medical College, and there it is been supplied at 130. So they are yet to, my lord, complete the tender process. Same with, my lord, Kokrajhar. Tinsukia process not yet initiated, my lord, on the day when I got the inspection, I had a telephonic inspection that it has not been. Nalbari, it is now this present case litigation. Nagaon, my lord, yes, as per Tezpur Medical College. Rest, lordship will see. In fact, my lord, for Borpeta, I will place the judgment of this honorable court that, my lord, thrice, my lord, there was a litigation every time. And this particular bidder who was there, my lord, L1 bidder, he was continuing from 2019. For some reason, for litigation, he was continuing. So finally, my lord, they were like, we'll reject him again and he will go for litigation. Again, there will be a stay. So they said, whatever is there, we will see tomorrow. Look at it. Because he was continuing from 19.
Yes, so
I'm aware because I was a part of the.
you just give me for Jorhat and Barpeta. I think these two will do.
Jorhat, Borpeta.
Right.
The Jorhat is says fixed. Lordship will see. I will have the.
Oh, fixed. Okay, fixed.
Might be something there because these are new colleges we have been come up. So there's how some are managing. And the civil hospital, whatever was.
It is not on the basis of a tender, that means.
Seems so fixed. That's why Nalbari was following my lord Borpeta. Borpeta at that point of time was 142. That's why I'm saying.
The problem is there is no price against each of the item. If you see, my lord, supply to that article to animals, there is each item that they mark the base price. Suppose you want to supply meat. I have done, my lord. Suppose you supply mutton. So mutton, the price is given. Against that, you quote that price. But here they have not quoted any price.
My lord, they will have to challenge the tender.
My lord, I want to give a clause. What is their problem? I want to give a clause. 70.
Then, my lord, one thing, my lord, will solve everything. If we can give a letter to the petitioner to justify his rate, how he will supply.
No, let him justify.
That will be part of, my lord, the authority will consider if they are satisfied that he can supply.
Correct.
Probably, my lord, this will.
This will solve the issue.
Up to them, my lord. At least let the justification be placed. How he can supply at 178 rupees.
We will come.
We will give a letter.
Give a work order. I
No,
will
no,
show that these are the items. that
Justification,
supplied.
clarification.
You verify it, whether these items we give to patients, you see yourself.
Lordship will
I know
kindly,
the quality. That is why in that I have shown my lord, if they found it unhygienic, then they can cancel it. How they are going ahead? My lord, they are
Lordship will say
speaking.
page 57, part of the tender, my lord. Now, Learned senior friend was referring to that. Page 57. Evaluation of offers for award contract. The multiple bidders, we had Lordship will say one. Nalbari Medical College and Hospital shall consider awarding the contract to those bidders whose offers have been found technically, and Lordship will see the comma, commercially and financially accepted, commercially.
Correct.
The lowest per day cost of providing food will be considered as the lowest bidder. The institute reserves
You
the
see,
right
it says as per
Counter
attached BOQ. This BOQ means bill of
bid of
quantities.
quantity, yes.
Now, where is that bill of quantities and the rates that has to be made against each,
Yes. No,
each of the
Bid of
materials?
quantity I can place, my lord. It will be, I can download it. But Lordship will say next line. The institute reserves the right to counter offer prices against prices quoted by any bidder.
Correct.
If that option Lordship is allowed at this stage, we can, my lord, at least we can negotiate with the petitioner also. Instead of going for a fresh tender and all. If such a opportunity is given, we
But
can.
let them show the minus for competent and.
The board beta, I can place it, but that cannot be a ground, my lord.
Let them
Just-
show, like.
I leave it to Lordship, my lord. Whether that can be a ground for, my lord, considering this. For another minus in another tender, will be a.
No, it won't be. But I just,
Going to that extent, my lord.
this board wants to know how it is being decided, whether the prices of
It's
each
not
rate
about
is
the
being
money, my lord.
considered.
It's not
Huh?
about the money.
But
supply.
that is what you've been reading. That's what you've been reading. The Tata Cellular, everything is all about
No,
money.
Here the ground was, my lord, it's the finance of the state. Here we are, my lord, interest is the patient, public interest is the, my lord, pivotal here in, my lord.
No, it's not only,
Same way, my
you
lord, the
cannot give,
finances of the state is the public interest.
government hospital is never going to give 5-star treatment to patients.
If
They're going to
Lordship
give
writes
normal.
that, my lord, at least whatever we are trying, my lord, if that is, my lord,
So,
brought down to this level by.
no, it should be given,
Investigation,
it should
my lord, by
it should be
some
given
petitioner. Maybe,
good things
yeah.
should be given at the cheapest price.
Of course. That's why I'm saying, if you can justify, that's a different issue. They can always, my lord, look into that.
You bring the Barpita, let us see.
I will, my lord. Lordship will
Jorhat though is fixed, I don't think.
No,
it
let me
happens.
place, my, there may be something, my
Okay.
lord, why it is fixed, I can place that.
Okay, right. Mr. B. Gogoi shall produce the meeting minutes of the bid committee.
Yes. of
Bid
the-
committee for fixing the rates of the dietary articles provided
By the present supplier, my lord, that present supplier.
in respect of JMCH Jorhat and FAAMC Barpita as on date.
As on date, yes, ma'am. Or 9th or 10th, my lord, on a hearing day, it will be more.
Okay, list the matter on 10th.
10th, my lord.
Oh, 10th or no? Sorry.
Then 9th, my
No,
lord, it will be on 9th.
9th is Monday.
After admission, my lord, after the admission process, it will be 3 by 3.
Huh?
After the admission.
11th, you can try 11th.
Yes,
11th.
Lordship will direct the director of medical education.
Okay, you just said the director of medical health, what?
The director of medical education.
The director of medical education.
No, that's right, my lord.
Okay.
Yes, respondent.
Mr. B. Roy shall obtain the required information from the respondent number 3
Lots.
with regard to the above. Huh?
Lots of.
I put this also. Item 12.
But I something. So I pay before your lordship, with the plea that and about to withdraw the petition.
With liberty to file a petition. I think better. Yes. Miss A. Bora, learned counsel for the petitioner, submits that the petitioner has not been able to, that submits that she has not been able to communicate with the petitioner. Yes, sir. Mr. No, she accordingly prays that she may be allowed to withdraw the writ petition with liberty to file afresh. Inasmuch as the matter has been pending for the last 7 years. Mr. Arupadhyay. Enupadhyay. The counsel for the irrigation department submits that he has no objections to the thing. Accordingly, the writ petition in this case has withdrawn with liberty as paid.
Lord, follow you.
Certain I made a mention in the morning hours, while taking consent for the petitioner.
So you took consent from the petitioner.
Yes. Actually, last night, but again, I informed them to be present. They said that we are coming, but after sir, and
So
When
was the high tension wire over the brick-kiln or what? The brick-kiln was constructed later,
yes,
later.
Yes.
After the high tension wire was,
yes, it was constructed.
then what remained?
Yes,
There's nothing to be decided then.
yes.
Unfortunately, they're not here. Or fortunately, they're not here. Right, no one appears for the petitioner on call. The petitioner claims compensation for damages to his brick-kiln on the ground that the erection of the high tension wire over the brick-kiln caused damage to the brick-kiln. The respondents, on the other hand, have taken a stand that at the time of erection of the high tension wire, the brick-kiln was not in existence. As the petitioner is not represented, this is the matter after 2 weeks. Anything survives here?
No, well, I have that across my love.
Huh?
I have that across my love. It's the land does not. We in the advertised location, my love.
Land is not in the advertised location.
This is the report for LAC, my love.
Huh?
In either side, it will be 2 kilometers radius. 2 kilometers radius. That should be.
This is a disputed question of fact. Okay, you know, uh-huh.
In fact, he has admitted, my love.
Then what remains?
The advertisement is, it should be within Kolkata district. But Bangla Civil Madrasa is in the border of the Kolkata district. In one side, it is Kolkata district, Bangla district. In the other side, it is Kolkata district. In Kolkata district, in other side, it cannot be 2 kilometers radius. Because it is Bangla district. So only side remains in the Kolkata district only. It cannot be either side, one side. So there is a mistake in the advertisement also. Because my proposed site is within 2.3 kilometers from the radius.
2.3. So and the requirement is 2. Then
now there is that I give a alternative land by alternative land provision of.
but when your first, see, alternative land will only apply when your initial land was within that area. But in the first instance, you do not come within that specified area.
I was selected. I have also deposited the money.
Okay.
They have
Okay.
I was selected and I was in the.
He was placed in group 3, my love.
Huh?
Now
Group
he was
3.
group 3, my love.
Okay. So the other group 1, 2 are there.
Yes,
or
my
what?
love. In
Also,
group
he
number one-
doesn't come into the picture then.
Now, my love, the respondent number 4, my love, the respondent has been selected in raw blocks, my love.
He's from group 2,
Group 1, my love.
group 1.
Nothing survived, my love.
Huh?
I was initially in the group 1.
Initially group one, but you're no more in group one.
But they have rejected my.
Naturally, you don't come within that area.
Workshop, there is provision for proposing a alternative land.
Can they have two outlets? Can they have two outlets in the same area? You were the first person wrongly selected. That's the problem. If you are rightly selected, no problem.
I was selected, and I have also deposited the money with it was
Wrongly selected doesn't give you any right. A mistake doesn't confer any right upon a person. What to do?
one side, it cannot.
One side, forget one side. It's either side. It's even if it's either side, you do not come within that 2 kilometer radius. What remains? No need. Why you bring it to? Why do you want to show me? You know the facts. Then you know the facts. You're not disputing the facts.
It's not within 2.3 kilometers.
Nothing survives. Nothing survives. You tell your client nothing survives.
The restaurant can consider
Ah?
alternative land, but if the restaurant can consider my alternative land, that's not the. He will available in good fee. I'll let them put out.
Now he can't be Malad. He already placed in group 3 Malad.
Huh?
He placed in group 3 Malad.
Group one is
You register lease the Malad. That's enough.
no. Group one, group two. What's the difference? Group
Yes,
one.
Malad. For group 1, he must be a own land Malad.
Own land.
Either in gift or register lease it, and group 2 for farm or farm Malad. Agreement for sale agreement. And
Third is the lease deed.
rather having in land Malad.
And he is the leaseholder.
Yes, Malad.
You have the land. No, where?
Advertised location, Malad.
Not in the advertised location. And now you want to offer lease land, leasehold land. So leasehold land. I don't know why you're pressing. You've got no right.
Direction to consider my prayer for my proposing a alternative land, what is it? That's the way.
You show me the law which says that more than one retail outlet is going to be given. Not law, I mean that decision. Then we can. Otherwise, there's nothing.
And third party right has already been created, Malad.
In this case.
Only problem is that you had provisionally selected him, no?
Yes, Malad.
But that doesn't give you any right. Provisional selection doesn't give you right.
We have also the direct, well, you are directed to pay the 50,000 rupees.
Huh?
That was also.
You paid the security deposit.
10%.
Security deposit will be returned to you.
No, Malad. This is a false declaration of.
Huh?
False declaration.
If it is a
False
false
declaration.
it's not in the appropriate location, Malad. We have invested money, Malad.
Tuition fee is 10,000, that is a different. that
It is a 10% of the security deposit, not the entire security deposit, Malad.
If it is filed on my direct document,
But where is your no affidavit submitted by you?
That's why when I am that report. This is a request, Malad, land investment committee reports, Malad. It is 2.4 kilometers away from the apparent location, Malad.
2.4 kilometers.
It should be Malad 2 kilometers.
You want me to dismiss it or you want to withdraw? I've got no other choice. If I've got a choice, it's okay. I could have thought about it, but I don't have a choice.
I'll issue this petition, that we can liberate it to approach the authority, Malad.
Okay, let him approve. Mr. Ayush Saikya, counsel for the petitioner, says that he may be allowed to withdraw the writ petition with liberty to approach the competent authority with regard to his grievance. Mr. S. Bhattakur appears for the
That's not 2 and 3, Malad.
point number 2 and 3, while Mr. S. S. Roy appears for point number 1. The prayer of the petition counsel is allowed. Writ petition dismissed as withdrawn, with liberty as written.
God bless you.
Nearly became, huh? Interim order passed the stands wicket. But then you see, you have to be careful next time. Once you declare someone provisionally selected, then they become rich in the eyes of their neighbors.
There are pleadings of the petition that he is an unemployed youth, my lord.
So what? But still, once you're provisionally selected, you become a petrol pump dealer.
Yes, madam.
Then all dollar signs comes into their dreams, everything. So you've got to be very careful,
Yes.
giving them false hope. This is infructuous.
No extra copies were served to us.
This is for what? What is this case about? Okay, this matter is regarding security guard. Initially for 1 year, extendable by 2 years. We'll wait. Tell your senior to come.
Yes, we have received the record. But Lordship, as we have stated in our affidavit, that there is no such record of handing over the fishery, and it is also not available in our record, Lordship. No such.
What? There is no record of you handing over the fishery to him.
No. He handed over the fishery to the.
He handing over the fishery
Yes,
to you.
yes. Which is, in fact, we have stated in our affidavit also.
So what is to be done?
Ultimately disputed facts, Lordship.
Thing of the fishery is not as important a question. The question is with regard to the remission. Fishery was initially handed to us pursuant to a general process. After
The period of the settlement was for how long? And that was to end when?
2009.
19. And if you have not handed over to them, what are you doing for the last 5 years?
I was not able to fish in that particular.
So you have not. No. So you have not handed over the fishery. That is a.
Information.
Yeah.
I will just annex that presentation. The petition. But we sought for remission time and again.
What? You're not able to take possession of the fishery or what? What is it?
Their status, actually what happened, that fishery is no more. Some sand came on it.
We even went to the civil court.
Because
So
he raised the issue regarding, on last occasion, Lordship, this issue was raised by him, that it was handed over. That's why this court has called for the records, Lordship. And our stand was clear from the very beginning, Lordship. It is it is there, very much there in our affidavit also, Lordship. So ultimately, Lordship,
the fishery was settled from which year to which year?
It was awarded on 27/9/2012.
Prior to COVID. That excuse of COVID goes. Then
And not because my ground is that there were some illegal fishermen who were fishing in the fishery. And we could not. And we had filed a title suit. There is a judgment of the civil court saying that we could not actually fish. And civil court directed to award compensation and hand over the fishery to us. In spite thereof, we were not handed over the fishery. The execution proceedings also stopped because they did not appear. So they could have at least taken those facts into consideration and considered my application for remission. Those applications have not even been considered.
Bakijai proceedings are
They are
issued.
pending.
Yeah.
So at least if the admission is considered, that aspect can be considered in the Pakistan proceeding as well. I may be given an opportunity to Pakistan proceedings. At least they may consider take into consideration the facts and the judgment of the civil court, which is again finally given. Those things could have been considered.
Where is the agreement, settlement agreement?
The award is at page 14. Paragraph 3 of that order,
Yes, what is to be done?
Ultimately, Lordship, whether he was able to fishing or not, or whether it was handed over to not, ultimately it involves a factual dispute, Lordship.
No, my limited prayer at this stage, I may be allowed to, they do not have the applications of remission, I may be allowed to submit a fresh application. They will consider the facts and pass an order.
The problem is that title suit, I mean, that suit that you filed, that was ex parte.
That was its part.
Then we do not know if there was really any encroachment or not. That was your case only.
Right here only, there is an order of the, there is a decree notice in my favor.
Were they a party in the title suit? They were not a party, very conveniently. And you want remission from them.
I have also annexed the certificate of the Kavra. That is there.
Mr. Kausil, you want remission from them. You file your case against some XYZ. You don't make them a party. You do not know if you have filed the suit bona fide.
Let them consider my application for remission. I will place all the facts before them. The fresh application.
We'll take it up again.
Lordship.
When?
Any day.
Unless the matter of a two. Or we can dispose it of also, I don't know.
By allowing them to file a fresh representation.
But then that is the Bakijai palace, that Bakijai proceeding is also
We will
going.
participate in the Pakistan proceedings.
Huh?
We will participate. We will be given opportunity. But the remission part, we will consider.
But that will amount to staying the Bakijai proceeding.
It is already stated by this honorable court.
We will take it up, okay, after lunch we will take it. We'll try. Yes, Mr. Goswami. Supplementary demand. Whether approved?
Lordship, it is not approved and it was returned back to the department by the finance department. After that, Lordship,
Why? Did it return back for some clarification or what?
Lordship, this was for communication. Lordship, after that, the department has pursued Lordship for contingency fund. And director have 26/11/2024. They have submitted a fresh proposal for a contingency fund. Because of the cabinet decision for contingency fund, CM approval is required, Lordship. Department is in process to get the approval from CM, Lordship, and within 2 weeks, the proposal will be submitted to the finance department, Lordship. Some time may be required in this regard, Lordship. 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 Proposal, Lordship, that and
For the contingency fund.
Lordship.
Okay, right.
And petitioners, both cases are included in the proposal.
Okay, right. Heard Mr. P.K. Goswami, the senior counsel for the petitioner. Miss
Z Bora.
G Bora.
Lordship.
G or Z? Z means G or Z means Z?
Gita Sri, Lordship.
Huh?
Gita Sri, Lordship.
Gita, okay, G. Miss G Bora, learned counsel for the
Agriculture Department.
Agriculture Department submits that the supplementary demand made by the Agriculture Department to the Finance Department had been returned to the Agriculture Department. Full stop. He submits that the Agriculture Department has, however, in the meantime, made a what has made a
Contingency fund, Lordship,
contingency fund demand
Lordship,
on 26/11/2024
Lordship,
for payment of the contractual dues of a number of
Lordship.
persons, including the petitioners hearing.
Yes.
He submits that the same is awaiting the approval of the Honorable Chief Minister of Assam.
Lordship.
Full stop. Thereafter, no, she submits that the approval is expected to be given within 2 weeks.
Lordship, in process, Lordship.
Huh?
In department, Lordship, but they are proposed to submit before the CM, Lordship, within.
Okay, she submits that the proposal for the contingency fund is going to be prepared and placed before the Chief Minister,
Lordship.
Honorable Chief Minister, within 2 weeks.
Lordship.
Thereafter, on approval, the fund will thereafter be the dues of the petitioner will be paid along with others. Correct?
Lordship, that finance department, then we
And
have to,
again, everything is just one newcomer role.
we have to just submit before this, as part of budget.
This
financial
is the
year.
matter to give a date.
That's. That is a deal. Weeks.
They said 2 weeks.
Lord. Hello. Lordship, in this case, Seed Corporation has floated the tender, Lordship. Seed Corporation is a required party, Lordship, as Samoria is representing, and we have
Seed Corporation is a party in the writ petition. Will heard, Mr. S. Vishwakarma, learned counsel for the petitioner, and Mr. S.R. Barwa, learned counsel for the state respondent.
Yes, Lord.
The petitioner has paid for setting aside the impugn notice dated 14/8/2019, by which the petitioner number 1 was directed to show cause as to why the Bakijai proceedings should not be initiated against him on failure to deposit the amount of rupees 1,93,355. The petitioner has also prayed for a direction to be issued to the respondents to consider the petitioner's representations. No, the representation of the respondent, petitioner number 1, to grant remission of revenue. Next paragraph. The petitioner's case is that pursuant to a tender process, the petitioner number 1 was awarded settlement of 34 number Borali Mora fishery, while order dated 27/9/2012 at its quoted rate of rupees 32,226 per annum for a period of 7 years. However, the petitioner could not fish in the fishery as the same was allegedly occupied by persons who conducted illegal fishing therein. as the petitioner's representations for remission of the revenue due to illegal fishing conducted by miscreants was not being considered by the respondent, the petitioner filed title suit number 23/2014 before the court of the Munsif number 1, North Lakshmi. In title suit number 23/2014, the petitioner did not implead the state respondents as parties. Title suit number 23 of 2014 was disposed of ex parte by judgment dated 10/6/2015 as follows. Page 30. Page 30. Pencil apple. The decree was accordingly made in title suit number 23 of 2014 on 1/6/2015. 10/6/2000. The next paragraph, the petitioner's counsel submits that the period of settlement of the fishery ended on 26/9/2019 without the state respondents having taken a decision on the prayer of the petitioner to consider remission of the revenue payable by the petitioner. Instead, Bakichai proceedings have been initiated against the petitioner for recovery of a sum of rupees 1,95,355. Next paragraph. The petitioner's counsel submits that the fishery has been returned to the possession of the state respondents in the year on 18/6/2019.
2018.
18/6/2008. He praised that a direction may be issued. He submits that the writ petition can be disposed of if a direction is issued to the state respondent to consider the petitioner's prayer for remission in terms of the representations dated. Which one is enough? I think one is
Right, Lordship, but in case of remission up to more than 500, he has to approach the state, the fishery department.
The section of the government is, the rule says that the sanction of the government is required. I have a settlement order, how can I obtain the settlement?
Because settlement was given by the fishery department. Let me submit. Settlement was given by the fishery department, government. And normal practice is that in such situation comes for a remission, the party directly approach to the government because they are the authority.
then you file a fresh representation.
Press that will.
Okay,
that will suffice.
whatever, sir. Now, if the petitioner is allowed to submit a fresh representation to the state government for considering the petitioner's prayer for remission of the revenue payable to the petitioner, by the petitioner. Mr. S.R. Barwa, the learned counsel for the state respondent, has brought the official record, and the same does not indicate anywhere that the fishery has been returned to the possession of the state respondent. He, however, submits that the fishery is no longer a fishery
Lordship.
and it is now
It's
filled with sand.
sand.
Filled with sand. Gustav. So no objection. He submits that he has got no objection to the prayer of the petitioner for submitting a fresh representation with regard to his grievance. which the respondent shall decide within a specified time period. First time. Next para. In view of the consent of the parties, the petitioner is given the liberty to submit a fresh representation for remission of the revenue payable by him to the respondent number
One.
one, who shall take a decision on the petitioner's representation within a period of 2 months.
3 months, Lord.
A period of 3 months from the date of receipt of the representation and a copy of the disorder. The petitioner is also given the liberty to file the fresh representation within a period of 2 weeks from today. Till a decision is taken by the respondent number one, the Bakijai proceedings initiated against the petitioner for a sum of rupees 1,95,355 shall remain state. The writ petition is accordingly disposed of.
Public.
There being 16.
Infractors, no? Right. Heard, Mr. J.C. Gaur, learned counsel for the petitioner, who submits that the matter has become infructuous. Miss
I was representing respondent 2 and
I Das appearing on behalf of
respondent number 2 and 3.
2 and 3. Appears on first up. In view of the submission by Mr. J.C. Gaur, the writ petition is dismissed as infructuous. Item?
I found it in 2023. Matter was admitted. The record was called for the record reference section 1 of 2018. Over the registration not called for.
Huh?
Not called for that. Reference might not make.
Reference case number 1 of 2018.
2018 from central government industrial tribunal come labor court class.
So that has not been called for.
That has been called for by order dated 21/12/2020.
Correct. 21 to 2023.
That record is to be registered of that report.
Has been called for, but has not been received. So reminder has to be sent. Okay, right. Registry to send a reminder for the records of reference case number 1 of 2018 from the presiding officer, CGIT, Labor Court. Guwahati.
But
List the matter after 3 weeks, 4 weeks.
Okay.
This is the matter after vacation.
Complex.
Yes. So what is to be done?
Lordship, here the non-payment of the contractual amount is with regard to the Assam Seed Corporation. Lordship, they have to address your Lordship.
Assam Seed Corporation.
Yes,
Okay.
they are party. Lordship.
So Assam, who is the council is not here?
Yes, sir.
If they are a party, Assam Seed
Yes.
Corporation is respond number 4. Huh? But they are not here. What to do? Okay, right. No one appears for the Assam Seeds Corporation Limited, against whom the prayer for payment of the supply bills have been made. This is the matter on 18/12.
Lovely.
No one appears for the petitioner on call. No affidavit in opposition has been filed by the respondents. Yes, who is appearing? PWD. PWD.
Lordship, Mr.
Huh?
Who was supposed to hear Lordship? Lordship may give another date, Lordship.
Okay, this is a matter after a week. To enable the council for the PWD to obtain instruction.
Okay.
27 LPTA.
I have received today one review and काम after week में everyone 6 में along with the
Along with,
GPD
you want to file reply? Or what?
pilot I have go through if required I will
Okay, Mr.
and
M. Saikya submits that. M. Saikya, learned counsel for the petitioner, submits that he needs time to go through the affidavit in a position filed by the APDCL and file reply affidavit if necessary. Accordingly, on his prayer, this is the matter after 2 weeks.
the May paper beginning that on 13th.
13th, okay, 13th.
Much obliged.
So, huh?
Notice.
Yes,
Instructions
Mr.
is awaited, your lordship.
Okay. Mr. R. Gogoi submits that he has not received instructions. No, prays that he may be given time to obtain instructions. Praise the Lord. This is the matter after
2 weeks, your
2
lordship.
weeks. Huh?
30 similar.
13, 30 also, 31 also.
31.
31.
You are not there.
29 and 13 similar.
29 and 30 same, huh? And 31 also actually same. Who is the Ardhar? Who is appearing for the other side?
Maybe they are.
Huh?
What is better? After some time.
Okay, after some time. Yes, who is appearing? DFO. R.R. Gogoi was here. R.R. Gogoi. E-auction has to be completed, correct? Here. Yes.
Lordship, we received instruction, lord.
Okay. What?
This because the reason,
Is it going to be completed?
no, it's not complete because there is an order from the NGT, your lordship. Now, that's the reason we cannot open technical. It's a DSR committee, there's DS survey has to go on, your lordship.
Regarding this,
It's clearly given.
Anyway, right. Mr. R.R. Gogoi submits that the e-auction notice dated 29/4/2022 cannot be taken to its logical conclusion in view of the fact that the NGT Eastern Bench, Kolkata, has wide order dated 23/7/24 in OA number 86/2024/EZ and IA number 32/2024/EZ state all mining activities on the basis of e-auction/auction of minor minerals in the districts of Golpara and Lakhimpur. But this is Kachar.
This is Kachar, lordship, but thereafter, this whole order has been applied to all of Assam, your lordship.
First off, he
All of
submits
this.
that the order of the NGT has subsequently been made applicable
In different districts.
to all the districts,
All districts.
all the districts in the state of Assam. Where is that?
That order I don't have. There was an SLP filed in Supreme Court, which directed that this order.
Mr. R.R. Gogoi shall produce the notification issued by the government of Assam staying the mining activities all over the state of Assam. Pursuant to the notification number ECF number 491770 dated 5/9/2024 issued by the Special Chief Secretary bracket Forest to the Government of Assam, Environment and Forest Department. List the matter. When? When can you give?
After a week, your lordship.
Give a date. Ninth.
Item 26 is your own non-appearance letter. I asked for a petitioner. When first week after 1 week, by name may be for it.
Okay, right, Mr.
Yes,
SK, do you appear for the petition?
like
34. Yes, please, Your Honor. Petitioner has applied for land sale.
Yes, who is there? Who is appearing for the Mr. Barwa?
We have not received.
NOC not given.
Yes. We have not received the extra copy. We have not.
What? What to do? You what? Mr. Mr. S.D. Sharma submits that he will serve an extra copy of the writ petition to Mr. S.R. Barwa, learned counsel for the respondents.
That's 4 and 5.
Respondents number 4 and 5. The matter pertains to no objection certificate not being issued by the authorities for the sale of land by the petition. List the matter after 4 weeks. Why 4 weeks? It's only, they don't see. It's a simple issue. List the matter after 2 weeks.
Maybe
Give a date.
timing item 31. 1812.
Miss, yes, madam, is his name in the list?
Amount is admissible, lordship. Payment will be made as soon as received from the Assam government. Lordship.
Maybe fund there.
Huh?
Maybe fund is there.
Maybe will not do, but maybe I am 8 feet tall. How do you know? Like that.
Admitted in there.
Huh?
Admitted for it.
Admitted.
I know. What is his serial number?
This is something different, lordship. It is received from, if they will. receive
Where is
from
the
Assam-
parawise comment? Already filed? Okay, okay. Where is that? Where have we stated? Huh?
Lordship, page 44.
44, record number 3.
Okay. So you pay within a certain period, how much time?
As soon as fund received from Assam government, lordship, we have stated in para 44.
But there has to be a limit. Can you give it before kingdom come?
Lordship, if we receive from the fund, from the Assam government, this case will be considered.
But outer limit, how much outer limit? 100 years, 50 years, how much? 10 years, how much? You have to give some outer limit. At least during,
That is not
yeah,
specified by them. Time to time, Assam government will release the fund.
during your lifetime, during your lifetime of what? Of the petitioner or something. When can you give?
As soon as fund received from the
As soon as will not work, madam. As soon as you'll always say that not received. Then what happened?
No, lordship, this is a different fund, lordship. Assam government is releasing time to time.
Assam State Finance.
Is Assam
Releasing time.
is the Assam government a party here?
Uh,
It is a authority.
Okay.
PIP Assam State Finance Commission.
Huh?
Project is PIP Assam State Finance Commission.
State Finance Commission.
Okay, heard, Mr. BC Mosahari, learned counsel for the petitioner, and Ms. R.B. Bora for the BTC. Mr. S.R. Barwa appears for? You're not there? Okay, nothing.
All are,
The
all are there.
petitioner's case is that the petitioner completed the construction of ICBP road from Kaliagaon to Amguri via Lakhimpur under the 5th Assam Finance Commission during 2018-19 at an estimated value of rupees 3,49,44,595. Full stop. though the petitioner has been paid a certain amount of his contractual dues, comma, the respondents have not paid the balance amount of rupees 53, 32, 415. Question. He accordingly prays for a direction to the respondent for payment of his balance dues. Next para. Ms. R.B. Bora, learned counsel for the BTC, submits that the petitioner is to be paid the outstanding balance amount of rupees 53, 32, 415. Full stop. She submits that the said amount will be paid as and when funds are received from the government of Assam. Full stop. I have heard the learned counsels for the party. The affidavit in the position filed by the respondent number 2 shows that the respondents have admitted that they owe the petitioner the outstanding balance contractual dues amounting to rupees 53, 32, 415. In view of the admission made by the respondent, the respondents are directed to pay to the petition the admitted outstanding dues within a period of
And whether there is fund or not.
I don't know. That I don't know. You pay. You take time, but you pay. How much time?
6 months.
6 months.
One thing, head of account, debitable head of account,
Where?
head of account, annex of 1A.
1A of your petition.
Yes. Page number.
Okay.
Technical. Technical head of account. Maybe.
Anyway, that is there. They will do it.
Sometimes, if fund is also available, then also remember about the fund position.
I don't know which account. I do not know about the head of account. Within a period of 5 months. From
Please, 2 months.
they are not going to give you within 2 months.
Head of account is there, fund is there, there was fund provision clause. How it is for amount left out. Recently, then.
Okay, within a period of 4 months from the date of receipt of a certified copy of the sub. Read petitions accordingly disposed of.
Diploma.
35.
Blacklisting.
Yesterday, we have received the instruction, we'll file our affidavit.
Any notice issued?
Yes.
Then let him answer that. Yes. Is there any notice issued? In a parawise comments?
Yes, SOCOS was issued on 39/2024.
Let us see what is the show cause. What does it say?
That perhaps we could not take the printout. Can it be after some time, Lordship?
Next. We'll see.
On last date, Lordship directed me to obtain the status of the proposal, Lordship, that was forwarded by the Irrigation Department to the Finance Department, Lordship. Lordship, that is presently under consideration, Lordship. Nothing has been informed to me till today, Lordship. So, Lordship, may kindly grant me 2-3 days time, Lordship. In the meantime, I will have the.
Mr. P. Nayak, learned counsel for the respondent number 2 and 6 submits that the proposal for payment of the petitioner's dues are still pending with the Finance Department. He accordingly prays for a week's time to get the up-to-date status on the same. List the matter on, give a date.
37.
Same, but
My lord, they say, my lord, they have got some, my lord, views now from the judicial department. And now they will do the needful for, my lord, making the.
Who?
The PWD. She will give some, my lord, stricture, my lord, that either come up with a press, my lord, proper instruction, or the civil engineer be here. My lord, I'm fed up, my lord, with communicating with them, my lord, every day. Now it's, they speak about judicial department's view and all. They've got it. Only thing is required is, my lord, they have the sanction of 6 lakhs and needs to be paid to the petitioner. Give some, my lord, reasonable time and say either he comes or, my lord, they give a proper instruction. I'm not saying that it should be paid, but it's some proper instruction should be given. Once they say, my lord, they have fought for proposal, best proposal from the district authorities, once they will move the finance. Now they say, well, judicial.
where is that order? The impugned order? I mean, the order of this court directing.
Lots.
What is your name, madam?
Lots.
Ms. S. Dev appears for the petitioner. While
Yes.
Mr. B. Gogoi appears for the finance department.
Yes, sir.
This contempt petition has been filed due to non-compliance of the order dated 10/5/2019, passed in WPC 3689 of 2017. Whereas the respondents were directed to release the outstanding contractual dues of rupees 6,10,986 to the petitioner within a period of 6 weeks from the date of receipt of the order. The order dated 10/5/2015, not 19, 10/5/2019, passed in WPC 3689/2017, was received by the Chief Engineer's Office on 20/05/2019. More than 5 years have passed since then. It appears that the PWD, that the respondent is intentionally delaying payment of the dues, though the direction has been passed by this court more than 5 years ago. On the last date, that is 30/10/2020, the counsel for the respondent had submitted that the proposal for payment of contractual dues of the petitioner had been placed before the finance department for approval. However, Mr. B. Roy now submits that the views of the
Judicial department
Judicial Department is being sought.
has been received.
Had been sought for, and the same has been received.
Right.
Then
Require some further time to, my lord, take the.
accordingly, feels that some
Compliance,
further
sir.
time is required. On considering the fact that more than 5 years have passed for payment of the said amount, this court is of the view that a prima facie case of contempt has been made out by the petition. Accordingly, the respondent, chief engineer, shall appear personally before this court on.
Lord, she will say either comply or he will appear. If either
Okay.
compliance will be placed or he will.
Accordingly, this court of the view that unless the payment of the outstanding amount is made to the petitioner, this court would have to take,
Well.
resort to the Contempt of Courts Act, as a prima facie case of contempt seems to have been made out. Accordingly, unless the payment of the outstanding amount is made within 2 weeks,
Let it be in January, they will get some time, but this order will help.
within 1 month from today, the chief engineer will have to personally appear before this court and explain as to why the charge of contempt should not be made, should not be paid against it, should not be made against it. List the matter on page January.
And Lordship will say, well, if the payment is not made in 1 month, otherwise, Malad, it
Full stop.
can be. closed.
The presence of the chief engineer will not be necessary if the payment has been made. Outstanding payment of the outstanding amount has been made to the petitioner in the meantime.
1925.
That annexed G Lordship, so post notice was issued on 9/10/2024. Giving 7.
Okay, you filed your affidavit.
Yes, yes.
Mr. S.R. Barwa, learned counsel for
All the respondents.
all the respondents submits that. He has received parawise comments and will be filing affidavit within
2 weeks.
within 2 weeks. This is the matter on you date.
17. 38, 40.
Lordship, the headed account has been created, your Lordship. You see the instruction.
Okay, so this is the 2611.
2611, this recent one, your Lordship.
Right.
Where now the secretary will forward send letter to chief engineer asking him to send the supplementary demand or reappropriation of fund, your Lordship. So that will, they have said, they will be sending back today, your Lordship.
Okay. Mr. K. Mazumdar appears for the petitioner, while Mr. R.R. Gogoi appears for the respondents. In persons to the letter dated 22/11/2024 issued by the Under Secretary to the Government of Assam, PHE Department, to the Under Secretary to the Deputy Secretary to the Government of Assam, Finance Budget close Department for requesting to create one requesting to create a head of account for payment of the petitioner's bills, the Chief Engineer PHE Sanitation has written a letter dated 26/11/2024 to the Secretary to the Government of Assam Public Health PHE Department, stating that head of account has been created, which is as follows. 2215-022-105-26-009-E-GA-Roman 5. I'll just mention once more. 2215-022-105-26-009-E-GA-Roman 5. V, that means, Next, Mr. R.R. Goy submits that the
Now the under secretary will forward a letter to the chief engineer asking for a supplementary demand or for reappropriation of fund.
submits that the secretary to the government of Assam PHE.
Yes, under secretary lodge.
That the under secretary will submit a letter or has submitted.
No, not submit. They will do it by today. Your
Submits that the secretariat of the PHE department
Yes, sir.
will issue a letter to the CE PHE sanitation to make a supplementary demand for payment of the dues of the petitioner. This is the matter. After 2 weeks, to enable Mr. R.R. Goy to obtain instructions as to whether the said request for making a supplementary demand has been made and whether the supplementary demand has been made by the chief engineer concerned. This is the matter after 2 weeks.
All right, Lord.
41.
Their date. 18.
All right.
41.
You with the calendar. Oh. Yes. So this can be heard. This the supply of roll of bandages, not accepted. Quality
has been made, but in the middle of the contract, some testing was done and it was not as per the schedule.
Quality is not good. Then
That is the reason.
and what is wrong?
Reason is that we have supplied as per the specification of the tender.
Now that is a question of fact. How will this court know whether it is of quality or not?
That is the tender.
Anyway, right. Mr. M. Sarma, learned counsel for the petitioner, and Ms.
A Bora,
A. Bora for
respond number 2, 3 and 5.
2, 3 and 5. Submit that. Pleadings are complete and the matter can be heard, disposed of. Can be listed for hearing. Huh?
Yes.
In the hearing column or what?
We come up with the list.
List the matter in the admission column after 2 weeks.
42. So the Lajima note stated 25/11/24. It appears that though the Wakalakama have been filed for all the private respondents, there is a discrepancy with regard to the signature of the respondent number 13. Because it has been received by one lady, Anne Vega.
Anyway, there's many other respondents.
May I please, I'm appearing on behalf of the respondent number 4 to 25.
All.
All.
They are appearing even for respondent number 13.
Yes, ma'am.
She is not a party to this.
Oh.
No, I don't know because who is 13 because he has signed on behalf of one.
No, so he's appearing on behalf of this Deepak Sharma only.
Yeah.
No, not Deepak Sharma, I mean the Rakibuz Zaman Chaudhary, correct?
Rakibuz was the original, but the lady who has signed
this wife of late Rekibuddin. I do not know whether we can proceed, but unless they make a clarification that he is the wife, because we have not made a party.
Wakalatnama, let us hear Wakalatnama.
Wakalatnama is the third file in the thing. There is one blue file there along with the.
How does it matter? The issue is the same. It's only one. He says that it is respondent number 13. So how does it matter?
Because
he's appearing for everyone.
I'm not convinced. I'm saying he was a necessary party because the award was for his benefit.
So he's appearing for them, for all of them.
Person against whom we have filed the case has not signed the Wakalatnama. One lady has signed. Whether she is the legal representative, we have not made her a party. Neither it is there on record. Your lordship will find out.
Now, where is the Wakalatnama?
In the second file, blue file is there. Only the Wakalatnamas are there.
Respondent number 4 to 25. Okay. Okay, where is the signatures?
Signatures are there, your lordship, in the first Wakalat, there are two Wakalatnamas. The gold file to there. Not yet, sir. Blue file to report. Total Wakalatnama. There are two Wakalatnamas there. And the signature of respondent number 13, the lordship will find the first Wakalatnama on his signature number 20.
So we don't know who is who. It does not say that 13.
Signature number 20 in the first Wakalatnama.
20 is N. Begum.
Yep.
Wife of late Rakibuddin.
Yes. Now this
So Rakibuddin is number 13.
No, Rakibuddin is not
Acha.
Who's Samaj?
Rakibuz. Okay. There's no Rakibuddin.
That is the thing, your lordship. Though they have filed it, the Lazima court took a thing that whether number 13 is duly represented. Because they have filed it for behalf of all. There is no Rakibuddin on record.
Yes, tell me. Can you show this to him? Show this Wakalatnama to him.
I told she is neither this person is the party, neither she is the neither. Otherwise, services not be. It's just one for admission.
It is written Rakibuddin Zaman Chaudhuri.
Yeah, it's good night.
Rakibud Zaman Chaudhuri. It could be Rakibud Zaman Chaudhuri.
That was to be clarified by them.
So it is that Rakibuddin is this number 13.
13.
But he has died.
He is died.
If he's dead, then you have got to make an application for impleement.
They did not inform the court. They have filed the Wakalatnama.
First time we have appeared.
Huh?
First time we have appeared.
But then how can you have there in the Wakalatnama you have said deceased, late or something you have said, no, dead or something. So you know that he's dead. Correct. What have you written? Rakibuddin, what have you said? Wife of late Rakibuddin, no?
Wife of respondent number 13.
13 is not Rakibuddin.
It is Rakibuz.
That is Rakibuz.
Actually, actually, the bracket was written by
Let us clarify because I have to formally substitute the deceased wife.
You clarify, okay. Okay, Mr.
Hemanto Gogoi. H.
Huh?
Gogoi.
Hemanta Gogoi,
Hemanta Gogoi.
appearing for the private respondents, shall clarify as to whether the respondent number 13, Mr. Rakibuz Zaman Chaudhary, has expired or not. And as to whether the person in the Wakalat Nama, that is Rakibuddin, is the same person as mentioned in the same person as respondent number 13. List the matter when? After
2 weeks.
After 2 weeks.
Okay.
Okay.
Sorry, there was an interim that needs to be explained.
Interim order to continue till the next day.
Okay.
Yes, any objection to this application?
Yes, I filed the objection, Your Lordship.
Huh?
I filed the objection
What is your objection?
in the IA.
Yes, what is your objection?
And moreover, Your Lordship, in the IA number 3598, I haven't received the copy of IA 3598.
It's very easy. IA 3598, the application is that the applicant there
Yes.
should be made a co-applicant in IA 724 of 2023. That's all. He wants to become an applicant. He wants to become included as a party. Correct? That is the application.
In that I have to take instruction from my.
There's nothing instruction, no instruction. What is there to instruct?
And moreover, Lordship, after 1 year they filed this IA after the expiry of the petitioner.
Huh?
That is not true. Yes, Your Lordship. The suit has been without filing the abatement petition. They directly filed the IA. The petitioner.
This is a writ petition, Mr. Counsel. What is there?
Delay is not applicable even then, Lordship, that.
This is not a suit or anything.
In the year 2022, May 2022, the petition have expired and they filed this IA in this 2024.
No. I filed.
There is already an applicant. There is already an applicant. Okay, now that applicant's name is Rana Ashim Das.
Yes.
Already. Now this applicant is Moni Deepa Das. What is what? She is the sister of this other applicant. How does it matter?
Moreover,
Right.
Your Lordship, the gratitude amount is, we have already deposited in the Labor Commissioner, Silchar. So let the matter be remanded back to Silchar.
I'm not on the merits of the case. I'm just on the application. What are you talking about? Third, Mr. R. Sharma, learned counsel for the applicant who submits that Moni Deepa Das Dev, the daughter of the late writ petitioner, Ranjit Das, correct? Should be implemented as a co-applicant in IA Civil 724 of 2023. Correct? And what about in the main writ petition? No, I thought that is for implement. In 724 of 2023. Mr.
R. Paul.
R.
Paul.
Paul appears for
C. Khandile, respondent 1 and 2.
respondents number 1 and 2.
And for number 3.
While Mr. S.R. Barwa appears for respondent number 3. First of all, considering the application made by the applicant, comma, this court does not find any ground to reject the application. Accordingly, the applicant Moni Deepa Das Dev is allowed to be implemented as a co-applicant in IA Civil 724 of 2023, along with her brothers. the IAs accordingly. No, before that, you're right. The applicant shall submit a corrected copy of the cost title of IAS Civil 724 of 2023 before the registry within 3 days, within 7 days. The IA is accordingly allowed and disposed of. Then in the then in the IA 724. 724 is with you. 724. Next, right. In view of the order dated 29/11/2024, passed in IAC 3598 of 2024, Srimati Moni Deepa Das Deb, daughter of the late Ranjit Das, has been allowed to be pleaded as a co-applicant in IA Civil 724/2023. Mr.
R. Paul.
R. Paul appears for the respondents number 1 and 2, while Ms. S. R. Barrow appears for respondent number 3. This is application for what? For substitution. Full stop. This is an application for substitution of the late Ranjit Das, bracket writ petitioner, by the sons and daughters of the late Ranjit Das. That is Shri Rana Ashim Das, number 1. Number 2, Shri Rana Biswajit Das and Srimati Moni Deepa Das De. ये फाइल ऑब्जेक्शन out here. Huh?
Yeah, this one basically on 2 points. Number one, they are the total rate of the petition that I have been party. And secondly, there is delay. What they are claiming is there is some delay in filing the
Correct.
petition.
On considering the prayer made by the applicants, this court is of the view that the application should be allowed. Accordingly, 1, 2, 3 are impleaded and allowed to substitute the petitioner and their father, the writ petitioner, the late Ranjit Das. Where the petitioner, the applicant / writ petitioner shall submit corrected cost title to the registry within a week. Then I is accordingly allowed and disposed of. Then you write in the main case, in the main writ petition, in view of the order dated 29/11/2024, passed in IA Civil 724 of 2023, number 1, 2, 3, who are the sons and daughters of the late Ranjit Das, bracket writ petitioner, are impleaded and allowed to substitute the late writ petitioner. This is the matter after 2 weeks. That's all.